Item 1, my lord, on behalf of Mr. Satyajit Behr, appearing for the respondent, my lord. He is out of station, my lord. I pray for an adjournment.
I am for the appellant. I am for the appellant.
You say, are you opposing?
Yes, we oppose. No, my lord, he is saying he is out of station.
So you agree with the proposals? The request of learned counsel for the respondent needs to matter after 2 weeks. Learned counsel for the petitioner, there is no objection to the request.
Item 2.
This matter may be taken up any other day, my lord, because this brief has been misplaced. This has been allotted to another parent council. Newly it is allotted.
Next week.
No, 1 week after this.
2 weeks.
2 weeks time.
So he want to reconstruct his missing file, NCC's time.
Item 3.
Please, your lordships. This is the petition of the Union of India Railway has filed challenging the order of the tribunal. Lordship may annexure 1.
You are for Union of India.
Yes, ma'am. Railway.
You are senior panel counsel and CGC.
Senior panel.
panel. Yes, what is the case about?
Well, this is matter about the promotion to the post of assistant executive engineer. That there is a 2 provision, my lord. One is from the feeder cadre selection and the seniority, and another is from the limited department competitive examination. That is the 30%. Where there is stipulation is that there is no such provision for supplementary examination. Petitioner applied.
Those who did not appear earlier, for them supplementary examination is given now.
No, my lord. So far as the 30% is concerned, your lordship may kindly
So
see.
kindly come to para 7. Para 7 of the judge.
My lord, may I please read it, ma'am?
Yes.
Further contents of the respondent that there is no provision for the supplementary written examination for absentee candidate also fall flat in view of the chapter 2 section rules governing promotion of the subordinate staff.
It provides for not more than 1 supplementary.
Not,
Why do you say there is
I just, that is the error on record. You will also may kindly see the last page of my brief, page 52. I have annexed the rules. That is at page 54. Sorry, annexure 5.
207.1, huh?
Yes, my lord. There is two category of promotion, my lord. One is the feeder cadre, seniority with selection. So far as the LDC is concerned, you will also make answer 15.2. All the employees who will fulfill the condition of eligibility prescribed and who applied and are allowed to take LDC regardless of their seniority, the panel is prepared from among those who qualify strictly on the basis of the
provision for holding supplementary.
Yes, man. No obliged, man.
This you did not tell the CAT.
Yes, well, that vote has been on the presumption that
But see, it is an apparent error on the face of record. Appears like.
my lord,
Why don't you file a review? Why have you come straight away here?
that the court has been taken allowed in the 2 rounds also. Another that he has not been communicated personally. That is the reason I have before you also, my lord.
Issue the heard learned senior panel counsel appearing for the central government and its officials person. He points out from what is that annexure 52 page
Annexure
from
5, my lord.
5
Page 54.
supplementary examination for LDCE is not permitted. First of all, the case is made out for issuance of notice and for any stay order yourself?
No, that's
But personal issue emergent notice. Brother, tribunal relied upon the rule position,
yes, ma'am.
but you are banking upon circular.
That circular has been read for you also may kindly see. Para 7 is that only the
In the rule, what is the position?
207.1. Rule number 207.1.
This is that 207.1, madam.
Can you read that rule?
The circular will not supersede
This is the
rule.
master circular.
Problem.
It's the master circular, my lord.
No, the question is,
My lord.
rules are generally promulgated.
You lordship may kind,
Yeah. Rules are ordinarily promulgated under the proviso to Article 309,
my lord. Nice.
unless a statute is made in terms of Article 309 itself. To my knowledge, to our knowledge, perhaps. No statute is there. Only rules have been promulgated by the central government.
Right.
Because these are not Central Civil Services Act is not applicable. If that is so, as my brother said, which I did not notice, the rule position cannot be altered by the circular.
My lord.
So what is the rule position?
My lord, that has been reflected. You lordship may kindly again see the Annex 5 for a kind perusal of lordship. That has been extracted from the rules.
52.
My lord, para 207, one of IRF rules, my lord. That has been mentioned. You lordship may kindly see supplemental.
What is mentioned is rule itself. Whether this circular
Yes,
15.2
yes, my lord.
having the title LDCE,
My lord.
does it reflect the rule position itself?
Yes, my lord.
Where are the rules?
Is it a clarificatory circular according to you? What is this position of the circular? The master circular is in the terms of a clarificatory.
Then I may be permitted to place that rule, my lord. When you bring the
Rule
to
that-
cabinet.
Please bring that rule. So
We follow for this matter, week after next. To enable panel council to produce the extant rules applicable to holding of supplementary examination for LDC. Non-production may result into drawing of adverse influence. Yes.
Item 4.
My lord, keeping it to. My lord is keeping it to.
Huh?
My lord is keeping it to. One is posted
When do you want?
2 weeks after.
2 weeks.
Item 4.
Well, this case relates to regularization of services of the petitioners. The petitioners approached the tribunal, Central Administrative Tribunal, and their application was rejected on the ground of delay.
Delay.
On the ground of delay and laches. And my submission is, there is no delay. I have
Take notice.
But Mr. Pati, you have been appearing in this matter.
of India, my lord, not for BSNL.
I am for the BSNL.
You appear party. Any private party is only.
then a date may be fixed.
In service we can dispense with because you are accepting notice.
Plus your panel council,
My lord.
CGC,
No.
senior panel council,
No, I am panel counsel of BSNL.
panel issue notice, correspond. Learned panel council appearing for the BSNL on request. Accept notice for OP numbers 1 to 4. First one. 1 to 5. Notice to 6 is dispensed. Tribunals are not supposed to be made a party because of the latest decision of the apex court. Statutory tribunal.
Rules are also amended.
Opposite party one. I am
You are for one and
You are for one.
2 to
I am for
5.
one.
5 here, yes. 1, 5, so 2 to 5.
Yes. A date may be fixed.
Let them file the counter, whatever.
Notice.
Issue notice gone.
Yeah.
Item 5.
Item 5, no copy is served on BSNL, my lord. I am appearing for the BSNL, the contesting opposite party.
No, as per order dated June 25, copy of original application filed by counsel for petitioner at so and so is given.
Only
No copy is
they
given.
have served copy
I
on
have already served to the Central Council, to BSNL.
Give one more copy. Copy and
India itself is not a contesting opposite party. I am the.
As per rules, I have served the Central.
It's all right. Give them-
request is common. As per our request.
No, sir, I have served.
Let it come, my lord, 1 week after, my lord.
May I say one thing, my lord? While they have initiated proceeding, They have not given the provisional pension at the time of.
Anyway, you
No,
copy.
Shiva.
We can't order provisional pension in interim order. Therefore,
So that
just
may
give
be
a copy.
because of initial
When do you want?
Any day after 1 week.
Call a week after next. In the meanwhile, copy of the petition along with all the documents shall be served on CC
Jana. No, appeal. BSNL panel lawyer, BSNL.
panel council for the BSNL.
BSNL. L Jana.
Mr. L. Janam.
Right. Yes.
Item 6.
None appears. Then all that pass out subjecting the matter posted in the duly task in this query. So, pass out.
Item 7.
May I please your lordship?
Sir, 6, you want to appear? In 6, you are appearing.
No, man. Only item 5, man.
May I please your lordships? Challenge is made to the order of removal from service confirmed by the appellate authority and also by the learned tribunal.
Removed on what ground?
Removal on the ground that he has been convicted in a criminal case. 304B is there, 306 is there, 498 is there. But petitioner is not the husband of the deceased. He is the brother-in-law of the husband. So he has been implicated on the basis of 34.
But you are convicted.
Yes, I don't dispute.
Huh.
I have been convicted, but my grounds are, when I was in jail, I was given the notice for showing cause, and thereafter punishment was also imposed when I was in jail. So I had no scope to contest the matter properly.
So where is the requirement of?
No, because Maladi section 9, the rule 19 says CCA that conduct leading to the conviction, not conviction itself.
That's right.
My ground taken is they have punished me on the basis of conviction, not
19 may not be available to you after the conviction is recorded against you.
no.
It is before conviction is recorded.
No, rule 19 is very
You
clear.
can recourse to 19.
Rule 19 is very clear that it must be conduct. They must consider it on the basis of conduct leading to the conviction, not the conviction ipso facto. My prayer is that, my ground is that they have not considered neither the.
Now your client is in serving the jail prison.
On bail.
He is on bail.
On bail.
But conviction has happened.
Conviction, appeal has been filed, appeal has been admitted.
Stay has been granted.
No, stay is not there.
Read Navjot Singh Sidhu versus NC National Capital Territory.
Malad.
Conviction cannot be stayed.
Conviction can be stayed. I have not applied for that. That is another thing.
Therefore, you will not be given the post.
No.
To succeed there, kindly understand.
Malad.
There are 3 judgments of the apex court. When there is conviction, straightway you can be dismissed or discharged on that ground without putting any finding. Conduct leading to
Yes.
criminal case makes no sense. Your argument is rejected at least by 2 high courts.
But that is the provision of law.
That is interpreted not like you, as we understand.
Malad.
Number 1, even after conviction, you mean to say you should be retained in the job? That can happen only in
Only
EDM.
Malad, the simple reading of the section.
That
Rule
is meant to be
90.
the courts now. Since you are not reading those judgments, the problem arises. Law is not just what the text of the statute says. Law is how courts have interpreted that.
Naturally.
The source.
Do you have any judgment to support your contention?
I will come. Let it be.
No case.
Let it be listed next week.
What for?
I will say also judgment.
The facts are very clear.
No, facts are not clear.
Very clear.
Very clear.
To you, then unless you remove your goggle, they may not be clear to you. But our goggle helps us to make understand.
So your lordship may call it next week.
Why for? We are being heard now.
No, I will. Your lordship has said that Navjot Singh Sidhu.
The court is not meant for giving training to the lawyers. Lawyers, they come to the war field. You can't ask the enemy. No, give an opportunity, I will bring better Pashupatashra. That is not the case. That's not the, therefore pendency. They are all small matters.
Malad, let it be called next week.
No.
Any day.
No, an employee who has been removed from service on the ground of conviction and sentence levied by the criminal court after full-fledged trial, is seeking to challenge the order of the CAT, which affirmed if the orders of the authorities below will first. Next one. Learned counsel for the petitioner vehemently argues that in terms of Rule 19 of CCA Rules 1965, conduct leading to conviction and sentence is one thing, and conviction is another. And therefore, unless an inquiry is held in respect of the conduct leading to conviction, mere conviction, to use his own words, conviction ipso facto would not justify removal. First one. This is absolutely misconceived. First one. Next one. Learned counsel for the petitioner very fairly submits that after conviction and sentence, an appeal is filed laying a challenge thereto, and that the bail also has been granted to his client. First one. He very fairly submits that conviction is not stayed, not sought for at all. Stay of conviction has not been sought for at all. First one. It is a cardinal principle of criminal jurisprudence that once a full-fledged trial having been held, an accused is convicted and sentenced to undergo punishment, the doctrine of innocence does not avail merely because he has been enlarged on bail, appeal pendente lege. First one. In the first, this view broadly accords with the view of the apex court in Navjot Singh Sidhu versus National Capital Council.
Yeah, NCD.
So, petition. So, first, in the above circumstances, the petition being unworthy of merits is liable to be rejected in limine, and accordingly it is up to me. Next.
My appearance may be noted. I am appearing.
I have not heard you at all. Why your appearance? Where have you assisted the court?
I was always ready for
Just you may be ready. Unless we issue notice, you cannot barge into the court complex at all. Yes, next time. Otherwise, you will go and claim the fees, which I am against. Anyway.
Item 8.
In this case, they have already complied the order of the tribunal.
Right.
They have already complied.
Nothing survives.
Here, Lordship, I am for the petitioners. My senior is right, but the thing is that today morning I had to talk with the department officers. I have requested them to issue a letter, email letter to our office on this present position by which I can be able to place this matter.
No, we believe me, boss.
We record it.
We record each statement. You have complied it. Have you complied it under the threat of contempt?
No, that.
Have you stated in your record that we have complied this subject to prosecuting the writ petition?
No, that is not been mentioned. But the only thing, my submission, Lordship, the only thing is that, Lordship, without a congruent instruction from the department.
No. We believe him. He is the contesting party.
He is the contesting party.
If it is false, make an application and you recall your order. This order.
I am filing that order of the tribunal, and the affidavit they had filed before the tribunal by that content petition.
We'll take some page note of the affidavit from the your affidavit before contempt court.
Have they said that we are complying this order subject to its challenge?
They have made a self declaration that we are complying this order subject to result of the writ application. But my submission before your Lordship is, my Lord, tribunal issued the notation contempt requiring them to comply. They have made a self-imposed condition that they are complying this order subject to result of the case.
It's correct.
So far as myself is concerned, the applicant is concerned, my order has been complied.
That makes no sense. Suppose a decree for, you only understand, if a decree for money is complied with, You mean to say he has no right of appeal against
My
the
submission
decree?
is that, my lord.
No,
My
that is reversed by the Supreme Court.
My submission is, my lord, plain and simple logic is, my lord, they are not over and above the judicial forums, my lord. They cannot fix a condition for themselves, my lord. They cannot fix a condition. They cannot fix a condition. Beg pardon?
You are not understanding the position of law. You are not able to understand the position of law. I say that. Law says, where under the threat of contempt, an order is complied with, the right to challenge that order is intact.
My lord, my submission before your lordship is,
Better that he will make a clear statement.
With your
Why unnecessary? Let him make a clear statement.
Yes,
Lordship.
Then they have written here.
So therefore, he has to.
Contrary to the stand taken by them in the content proceeding, if he makes another statement, then
Yes,
we can
yes, yes.
accept
They
it
can make it.
subsequently. Let him bring written this thing.
Next
We will not press this
Next
petition.
week,
7 days. Only 7 days.
7 days.
Yes, 7 days. Enough.
The call after 10 days.
Grateful, Lordship. Grateful, Lordship.
Item 9.
May I please, Your Lordship? Item 9, I am for the petition. Lordship will be kindly granting 1 week after my lord.
2 weeks, that's very fine.
May I say one more? The matter was already.
No, do you want time or you want to argue?
No, I am placing from taking time, my lord.
Then I'm agreeable with you. Why do you argue?
With a prayer, my lord, that it can be disposed of in the admission stage. Lordship can be fixed by a date, my lord.
After 2 weeks. Yeah. On request of the conference of petition. Do not waste time. When we agree with your proposal, you should not argue again because it will be waste of the time. We cannot dispose of matters at all. Yesterday, half of the proceedings were held up because of that event, that particular bomb scare. Yes, next.
Item 10.
May I please, Your Lordship? Lord, the petitioner challenge the order passed by the Lord
Kindly make use of the mic. There are students, interns, they want to hear your learned arguments.
My lord, the petitioner challenges the order passed by the Lord CJ without the position of.
You are a borrower?
I am the petitioner, my lord. I am the
Petitioner of borrower or
Surety.
borrower, my lord. My lord.
yes.
Now, the petition, after fetching two of notice under Surprise Act, the petitioner represented his representation, stating therein to reconstruct the rephrase the unity as the unity has been stated by the MSME department. And under MSME project report, the bank was agreed to finance this unit. The bank was agreed to finance to the tune of 1 crore 26 lakhs. But the bank has under financed.
Everything is all right. Come to your prayer.
Miller.
Can you maintain this writ petition? You answer that part. Your prayer.
Miller. To issue writ of certiorari to set aside the order passed on dated 21/10/2024, 29/10/2024 under section 14 of Surprise Act 2002. Miss case number 151 of 2024 by Lord CJM Court of
Not writ petition.
Miller.
Possession is already taken now.
They have taken the possession, but they are contrary with the law enshrined in under section 13(3).
Challenge it before
Your
the
Lord,
clarity.
that has been challenged.
And
it is pending from 2022.
You will direct them to.
One petition is filed. I have kindly see last week he has visited this on a report.
We are proposing, you done. We are proposing.
My lord,
We
kindly
direct
see.
the DRT to dispose of that his matter.
Fixing it is 3 years has gone in place of 8 weeks. My lord, your lordship's kindly see last day is wait. Suppressing this. Let me allow to finish. Let her repeat, sir.
Once, will complete.
Let me allow to finish. Your lordship may kindly peruse the border part by Lord CJM. Yes. Lord DAT, lordship.
Were you before this court earlier?
My lord, 5 times. In other cases, you know, Miller, see this order. This is not advocacy.
He has to argue.
Man, what is this?
He has to argue.
Miller, I am approaching to this honorable court and begging a prayer before this honorable court for different cause of action. While a cause of action arose, I will be before your lordship begging a prayer. And during that, your lordship was not pleased, the petition would have been rejected or dismissed or anything.
One minute, sir.
Milord.
Please come to page 2 of your petition.
Milord.
You have given this declaration that the humble petition of the petitioner named so and so. Alright. However, for the other relief, he had approached this court by filing 1, 2, 3, 4, 5 time you go.
I consent.
Can you please wait?
Milord.
Question there.
Sorry, Milord.
How will this court will come to know that the earlier petitions, the cause of action and the relief sought for is different than the present?
Milord. Together different.
How we will know that?
If your lordship direct me, then I will present the certified copy which I obtained from this honorable court that the order passed in the separate CRLMP is for different.
A principal cause of action is there. For every ancillary cause of action, you will maintain one writ petition. What is the principal cause of action?
Principal cause of action, Milord, while the petitioner availed the loan from the bank, National Bank,
Cause of action.
and within a period of 6 months,
What is this called? Try to appreciate.
Just to
Appreciate. See, the principal cause of action is there. There are ancillary cause of action arising out of that cause of action.
Milord.
For every cause of action, you can't maintain a petition. You have to attack the principal cause of action by filing whatever proceeding you want.
that will go over.
You have been approaching this court time and again from 2016. You are the borrower.
Milord.
2016.
Milord.
And you are not allowing the bank to.
Milord, facts remains, while the secured creditor allow me gets loan up to the tune of 1 crore 26 lakhs on the MSME project, and the project was started, only 2 loan has been sanctioned or to the tune of 20 lakhs and 30 lakhs, one is term loan and another is cash credit. And thereafter, all of a sudden, they have stopped the loan and thereafter they started my account to be declared as NPA within a period of 6 months. Can a project can be completed within a period of 6 months?
That's all.
Milord, that is it there. Here I stand before your lordship with a prayer. My representation after 13-2 notice, I have presented before the bank authority, before the authorized officer to regularize my loan, reconstruct the unit. And that application remained as it is. Thereafter they proceeded and under section 14 they took possession. 13(3)(a) has been amended, your lordship, after the final validity on form under the Mardia Chemicals, your lordship, I may draw your lordship's kind attention to 13(3).
Have you taken up this contention before the DRT?
Milord.
Then the process is.
The final order has been passed. I passed the. Your lordship may kindly peruse. With great respect to your lordship, entrepreneur.
This you challenge in DA.
You have to challenge.
Lordship may kindly.
We should see the outcome.
Your lordship may kindly.
No, not like that.
Kindly 13(3).
No, sir.
Your lordship observe.
No judgment. Question. You are dismissing it first. Now, see, there is an order by the DRT. All these contentions were traded before the DRT. DRT, rightly or wrongly, did not agree with that. On this order, you should work out. Is it appealable order?
My lord. Yes.
Appealable order.
Appealable.
No, you file appeal against this.
Milord, facts remains. While I presented a petition before the law DRT, DRT rejected without
1 minute.
Milord, hold on.
Suppose if we make some adverse observation against your client, that will trouble him.
Milord.
Instead, we will give you some time. You file appeal. against this order instead. That's better idea. Otherwise, the impression which DRT has carried that you are unnecessarily delaying the recovery proceedings by tactics, that will remain intact. You have to challenge this order.
May I permitted to submit 2 line, my lord? In the meantime, the secured creditor has already auctioned my property with under valuation only to the tune of 58 lakhs.
Yeah. And take up that contention.
My lord, I will take up that.
All the contentions, sir.
My lord, right.
You want the order on merits or you want to withdraw the petition?
Your lordship, I pray your lordship may kindly allow me to withdraw the petition and I will approach to the DRT.
This, the petition prayer reads as an
In limitation part, your lordship may kindly.
petitioner, learned counsel for the petitioner, having vociferously argued the matter for a considerable length of time, now seeks leave to withdraw the petition with liberty to lay a challenge to the DRT order dated 10/9/2025, which has rejected his IA number 389 of 2025, filed in essay number 131, pending essay number 131 of 2022. Yes.
I may be permitted. I will kindly see the essay number 131 of 2022.
Correct.
As my lord has rightly pointed out, he has not only visited 5 times to this time, 2 times to the DRT.
Now he wants to withdraw.
No, my lord, that way, since long, in place of that is mandatory provision, and my lord knows very well why the Surface Act has come. In place of 8 weeks, he has taken more than 3 years, not less than 10 petition he is going on file of the one of the other. Again it has been rejected, again he is visiting, again he has come. Last order which has been filed, my lord, kindly see the order of this honorable court. He has told that order has been challenged DRT, but seeking direction to send the matter to CBI, which has been rejected, and it has gone to the DRT, and again it has come before this honorable court. By this way, the purpose of the legislature has been completely frustrated. 3 years has gone and he is telling one after another, everything. My lord, kindly see, after hearing the essay, my lord was pleased to direct this DRT that to file your written note of submission. My lord knows very well after the hearing written note of submission has been filed 23/10/2024. After that, he has already filed 3 petitions. Now only intention to frustrate the intention and to linger the proceeding.
Now he wants to withdraw the petition to explore the possibility of challenge to the said order elsewhere.
DRT he can go, but this essay should be disposed of, my lord.
Essay also.
Essay is pending still.
Still 2022.
We'll direct the DRT to dispose of this essay.
Yes, sir.
Yes.
With kind permission, that order has been passed. Finally, the non
After passing the order, he is filing it here. I will hear the IA.
I bona fidely submit that my prayer has been allowed by this honorable court, comprising the bench honorable Justice D. Das.
Don't drop the names.
Sorry, extremely sorry. Thereafter, the matter has been taken up. Finally, I am submitting something and some error has been come that must be rectified through IA. And so for that sake, I have filed the IA. All the IA has been filed with a genuine cause, with a genuine responsibility, as bestowed upon the entrepreneur. And so if I will not file, then something has been left out. And if you will go to the DRT or along DRT or before this or before that export, there the defect will be again detected. That will be taken to.
You are giving an impression to me, to us.
No, Mila.
What he is saying is true. If you want to withdraw, well and good. Otherwise, we will make observation and dismiss the petition.
No, I oblige to withdraw, my lord.
You withdraw unconditionally.
Unconditionally.
With the liberty to challenge it elsewhere.
No
other observation.
No
extension, no time.
No, my lord.
Yeah.
Only the limitation part.
No, we cannot. Limitation is a matter of legislature. How the court can do?
This and honorable appeals court also observed in several cases that limitation should be taken in linear
case.
You know, 1987 Supreme Court says, and also in recent
Supreme Court. 87 Supreme Court, just tell me.
It is collector Karnataka.
It is not a case where limitation period was specific.
That is true.
I have read that judgment. Which
that is true.
You are simply misleading the court.
My lord,
That counsel
I may be permitted.
No, he wants to withdraw that.
My lord, no, my lord, I am permitted to point out 2 lines of my written notes, then my lord pass the appropriate order.
What line?
What? There I have taken the parent, say, my lord, regarding the statutory date fixed in the act for disposal of the essay may be considered, and the essay as well as IA may be dismissed with cost essay become withdrawn. This here I have earlier, my lord, was
You
targeted.
want an essay to be disposed of as early as possible.
It already targeted is there, but still is going on regarding the procedure.
Because if essay goes, then everything goes. But that's the idea. They only keep on filing IA and IA and IA.
Instead, there is one more, because of order 43 rule 1 capital A. You can wait till an order is made on the essay, and when if that essay order goes against you,
Then you can take this.
this also can be a challenge in the very same order.
My lord.
That's how law is amended now.
My lord.
That is held to be applicable to these proceedings. With that observation, we will dispose of this matter.
Yes, that's a better idea for you. No, you keep
And you
on
want to
filing
withdraw.
repeat.
Simply withdraw, lordship, simply.
You love to go to different court.
Learned counsel for the petitioner, having argued the matter for a considerable length of time, now seeks leave of the court to withdraw the petition with liberty to explore the challenge to the impugned order elsewhere in accordance with law. First, in the above circumstances, petition is disposed of as having been withdrawn unconditionally.
And the essay may be.
First, the DRT is requested to hear and dispose of essay number 131 of 2022 within an outer limit of 3 months.
Yes, 3 months, my lord, already.
No, already they are. There already is the.
Withdrawn that petition. You have no voice.
8 weeks became 155 weeks. Then after my lord, whatever my lord, already it has been targeted. But he has not complied. Yes, my
Then
lord.
again a same order will be.
Within an outer limit of 8 weeks and report compliance to the Registrar General of this court.
Obliged, highly obliged.
Item 11.
Time is spent on mislead you.
The petitioner challenged the order of the learned cat, my lord, regarding the recovery, my lord.
Recovery.
Recovery, that without any
Recovery from salary or recovery from pension?
recovery from the area, my lord. That is recovery from the area which has been taken. That is due to the mistake of the authority that they have done a roughing machine, my lord.
Roughing machine.
The roughing machine has not been interpreted correctly.
Roughing machine is for retired people and class 3 employees.
Yes, plus only. This interpretation has not been done. I am before my lordship that.
Now we are asking you.
Yes.
To which class your clients belong?
I'm a class 3.
Class 3.
Coming under the ambit of roughing machine.
Roughing machine.
I said that's why my lordship on previous occasion asked that whether class 3 or class 4. I'm class 3.
Give that 2015, 14 or 15?
Yes, my lord, I am coming. See,
Give that copy.
that matter I have come. My lord, in para 7, it has been.
The tribunal is
Tribunal, even with this honorable court, the Jogeshwar Saab case has not been also taken in consideration. They have not been so for anything. My lord,
3-4 principles are laid down.
my lord, I am placing my lord.
5 principles have been laid down.
My lord, the last principle, my lord, I am placing before my lordship. I am permitted to place the convenient my lords to for appreciation.
Third employee.
And that is
One second, sir. What kind of communication? Recovery from the employee class 3 and class 4. Recovery from the retired employees, another. Recovery from the employees when the excess payment has been made, the period in excess of 5 years. Before the order of recovery is issued, recovery issues to an employee will wrongfully be questioned that you will appear better but negative for the rights of What is the amount of recovery?
amount of recovery, my lord, 3,19,000, my lord, but I am placing. In Annex of 4, my lord, can have a glance.
Just, you don't have any glance. Answer the question. What is the amount?
Amount 3,29,153.
3 lakh?
3,29,153. That is, some area has been given, my lord, with effect from 2004. I have declared as a temporary status employee. So that's why it is
This area relate back to how many years? Because beyond 3 years.
from 2004 to 2018, my lord. That is, they have calculated that I am continuing in service and discharge the duty. But they have not taken into consideration.
Recovery. Limitation. Issue notice. Issue notice. Issue notice.
I am appearing for Union of India.
CGC.
My lord, Senior Panel Counsel.
Senior Panel Counsel.
Notice
On request and subsequent notice for OP number 1.
1 and 2.
1 and 2. Emergent notice to the rest.
Matter of respect to service, the department.
Notice to 49 is dispensed. Why are you impeding? I have been seeing so many cases where you are impeding the tribunal. Tribunal is not
Register for communication only, or not that issue.
No, it's not. The rules is now after Supreme Court judgment, all the High Court.
Henceforth, my lord, I oblige my lord. Henceforth, I will not. I will dispense.
OP number 9 is dispensed.
Dispense.
It is neither necessary nor proper.
My lord. Oblige.
Item 12.
Have you seen Rafiq Masi?
Yes, sir.
There appears to be covered by Rafiq Masi.
Yes.
Then we'll dispose of the matter.
Because the telecommunication chairman, they are the employer.
Legal issue.
They are the employer, they have
Legal issue.
That panel.
Oblige.
Yes.
Item 12.
The petitioner availed a loan from the Orissa State Financial Corporation on 8/5/1978. In the year 1999, I cleared all the dues.
How much loan?
Well, its loan was, principal was 3,03,301. I paid 20 lakhs. I paid the entire amount as well as the interest of 20,463 rupees 65 paise.
Totally, how much you have paid?
Well, I have paid around
Principal amount plus 20,000.
plus 20,000 all in.
That you have paid when?
Well, I have paid in 99.
99.
Yes, I issued them a letter that you give me a no due certificate.
After 21 years.
78 was the loan, 99 was clearance.
78, from 88, 98, 99.
90.
After 21 years, you have paid it.
Cleared.
The rate of interest.
Well, that is not in dispute. That the agreement I don't have. But question is, I have cleared the dues.
You want to know?
Yes, madam. The rate of interest.
Is it a commercial loan?
Yes, ma'am.
What is the rate of interest?
That I have not mentioned, madam. In fact,
So have they accepted the fact that they?
Yes, what they did, my lord, from 99 onwards, I am writing to them, give me no due certificate. In the year 25, they rack up and say that your dues is not cleared. Your lordship may kindly turn to page 17.
What is the due now, according to them?
Now they issue a due that it is 8 crores 29 lakhs 37,515.
8 crore.
Yes.
Very.
My lord, we kindly turn to page
But
20.
if 99, if you have paid,
Yes.
why have you slept over for
No.
a long time?
My lord, I have been writing to their own.
You should have come. Unilateral letters after letters will not help you.
Kindly see page 17. My lord, kindly see page 17. Kindly see page 17 for a moment. Annexure 1. With reference to your letter dated such and such, this is to inform you at the present there is no outstanding due in your loan account. This is their letter to me. However, the figure is subject to reconciliation of the loan ledger, which is going to be at the end, and confirmation of payments made by you through checks.
Now they have reconciled 8 crore.
Well, then limitation question, my lord, how? After so many years, can they take up even a money claim against me? From 99,
You take out notice, you see.
no, I have already served to the panel.
What is this? Try to be little reasonable.
Even robbers were little kind.
We just received a copy of the
Issue notice. Learned panel.
They are forgetting that limitation question in money claim.
There are many aspects. Yes, the mortgage, it will be 60 years. Whatever it might. Issue of emergent notice, learned panel counsel, saying so and so on request accepts notice for rupees. First of all. Next time, matter lies in a narrow compartment of the same after 4 weeks. And in the meanwhile, it is open to the notice to file counter if failing which right to file one stand for fee.
My lord, I have filed an interim application. No coercive measure pursuant.
Yes. Petitioner has filed an application in IA number so and so supported by an affidavit seeking interim protection pending litigation. First of all, learned counsel appearing for the petitioner with vehemence admits that his client has already made an entire repayment and therefore now the recovery in terms of astronomical figure of 8.29 lakhs
37,515.
There is more serious sufficient. First, in the above circumstances, application having been favored, recovery in terms of impugn
Next 15.
dated 13/10/2025 is hereby starts till next date of hearing.
Grateful.
Item 13.
90,311.
May please alert. The petitioner is a company. The electricity department has issued and outstanding dues of 18 lakh something, which I am challenged before the appellate authority. Yes. The executive engineer grievance redress forum Bhubaneswar. Thereafter, he has rejected the same. I have approached the ombudsman. The ombudsman, however, considering that the period in which the demand was issued, on that period, meter was functioning slow. However, directed to pay the outstanding amount of 10 lakh something. Well, also kindly see Annexure 1, page 13 for a moment. Operative person of law.
This is the ombudsman short.
Yes, sir. I am challenging the orders of ombudsman, Lord. Annexure 1, page 13, the operative portion, Your Lordship. In view of the discussion stated above,
It is rejected.
yes, my Lord. But
What is the amount due?
amount due is 10,99,278 as per the orders of ombudsman. Earlier it was
You file you deposit 6 lakh here.
Your Lordship 4 lakhs because I have not used running my
Case you have to examine, na? Whether you are instrumental in
Slowing down the meter.
slowing down the meter. All
And
these-
they have physically verified.
No, that
the meter.
everything has to be verified.
Yes, they have verified on my request. Thereafter, on verification, they have reduced the amount from 18 lakh to 10 lakhs.
If you want interim order, you have to make the deposit.
It may be 4 lakhs because only it is 4 months.
5 lakhs you will. 5.
50%.
50%. Issue emergency notice. First one. Started AGA. Any AGA is here in our court.
Electricity department.
Mr. Marana.
ECODL would be the right person to answer it.
Marana.
Take notice. Learned, your AGA or
ACO, Additional Standing Counsel.
Additional Standing Counsel. Additional Standing Counsel, Srimati so and so is requested to accept notice for OP number 1. First of emergent notice OP numbers 2 and 3. First, application draws the petition counsel for the petitioner draws our attention to application in IA number so and so seeking interim protection. First the said IA is supported by an affidavit. First he very fairly submits that there is an adjudicatable case, and therefore he will show his bona fide by depositing 50% of the amount in demand within 2 weeks.
4 weeks.
Within 4 weeks.
Yes.
Demand, the first installment 4 weeks in equalized monthly installments, first installment being of for 2 weeks and the second being of 2 more weeks. So, first one. It is fair. This stand is fair. In the above circumstances, application having been favored, the impugned order is stayed subject to petitioner making the deposit as has been undertaken before us, filling which the interim order stands located on its own.
Item 14.
Against the order of the Central Tribunal, the petitioners filed a writ application. The writ application was disposed of by this Honorable Court by the order under Annexure 4 to file a review before the tribunal on the ground stated there in one. Against that, and the period of delay which had occurred during pendency of the writ application was directed to be condoned. So, Lordship will see it is at Annexure 4. Thereafter, the petitioners filed a review application before the Central Tribunal, and the Tribunal, by order under Annexure 10, has condoned the period of limitation, that pendency period of writ application, but has refused to condone the delay which occurred from the date of order to the date of filing of the writ application.
When was the order passed?
If your Lordship, that is your Lordship, relevant portion is at para 9, page 178.
Tell the dates.
Date is, my Lord, the
21, 11, 19 was the order passed by the this court.
Yes, my Lord. Yes,
when have you filed the appeal?
4 months after, my Lord, 9/11/2006.
9?
And admittedly filed the writ petition before the Honorable Court on 21/4/2017. 9/11/2016 to 21/4/2017. Around 4 months.
After the order was passed by this court, when have you filed?
We filed it at time.
When?
That period has also been condoned. I am the placing that.
Pendency period is condoned.
Pendency of the period of the writ application is condoned. But prior to filing of the writ application, from the date of the order of the tribunal, there was a gap of 4 months. They have not condoned that period because that was not explained in the review application. My humble submission is
right. But I have to report something. That is not. What is the period for review? Limitation period for review?
30 days.
30 days.
30 days.
Is there any provision for condoning the delay?
Not the High Court directed and
I directed only for the pendency period. 14.
Only during the prosecution of the petition, section 14 is made applicable.
Yes,
but you had approached the High Court 4 months after the order was made.
Yes,
therefore, we are asking you, suppose if you had filed the review after 30 days, is there a provision for condoning delay proved in filing the review petition? Which is that limitation period?
Limitation period, my Lord, is 30 days.
30 days.
Read.
30 days.
Any provision for condoning delay?
My Lord,
this review petition is filed under which provision?
Review, my Lord, under section 34.
Section 34. Therefore, order 47, rules 1 and 2 would not apply. Under 37,
my Lord,
which act?
Well, let me examine.
Let me see the paper.
I will examine.
Whether section 5 of the Limitation Act is made applicable?
Yes, my Lord. Section 5 of the Limitation Act is made applicable. I have filed the petition.
Do you have the act with you?
No, my Lord, if you are not
See that we have no order.
The limitation petition, my lord. Under section 22(3), review was filed.
22(3).
The review was filed, my lord.
Whether 5 of Limitation Act is made applicable. Basics also you do not make research income. Problem is that.
Mr. Behra is sitting, you master of this administrative tribunal. Is there any?
What is the issue, madam?
Section 5 limitation is applicable in the review petition filed before tribunal? No.
So section 30 is specific.
So section, whatever has been provided in the administrative tribunal. That's all. Section 21 is the only provision for
condoning
litigation. And condonation provision is there.
For here, no.
As far as the review is concerned, my lord, so there is no provision there. However, there are a few judgments which says that in case of a review also the same principle which has been provided in the Parent Act may be followed. And there are also contrary judgments.
That is AIR 2015 Odisha full-based decision, page 49. This honorable court has already considered that aspect and has
To that judgment?
AIR 2015 Odisha, page 49.
Thank you so much. Let me know lawyer is able to say that.
Let me examine, my lord, if you lord.
No, just look into. Very best. You'll come without preparation. Others thank you.
I'm sorry, my lord.
Because that judgment.
Your my lord.
How much time is spent in this court on small? Where is the preparation in the bar? All substandard, barring few. Yes, how much time you are spending on preliminary things? People are looking. This is online court. $2015, 2015, Orissa 49. No reading, nothing. 2014, you put it, make it 2015. No, but they have said in. Kumar Farida.
The first one.
First one.
Yes.
Yes. 5 applies. You take notice. Did you see condonation of delay of 4 months?
Yes, my lord. For entire period, the application was filed, but it was partly allowed. For that particular.
No, you are wrong. She kindly come to page 178.
My lord,
that application you have not sought for condonation of delay of that period.
Your lordship may kindly turn to page 176. Yes, my lord, I have seen it. Your lordship may kindly turn to page 176, second paragraph. The UAE, Union of India and others applicants in this review have sought to condone 941 days of delay, calculating the same from filing of the writ petition on 21/4.
Filing of the writ petition. But before filing of the petition?
Till the date of the order of the Hon'Ble High Court of
Orissa.
Orissa.
The tribunal is correct.
Thus, going by the decision of the Hon'Ble Court of Orissa and the law of the land, the delay from 21/4/2017 to 20/11/2019 is hereby condoned. It was partly condoned.
Because the rest of the
you have not sought for.
and you have not sought for.
That's the observation of the tribunal. What to?
Well, my humble submission is, well, this Honorable Court entertained the writ application and ultimately directed to condone the period of pendency of the writ application.
They have done that. Tribunal has done that.
We would have given indulgence if there were a private party. You are Union of India. Correct. We will not give. Private party we can be not to Union. If so casually we are doing, keep on approaching the court, and you have to read the order of the court, to edit the letter and spirit.
A delay of 3 years was condoned, but 4 months was not condoned on technicality. High Court technicality.
In making the panel of lawyers, do they not see the merit at all? No, brother, nothing. Because power to condone delay is not inherent. It is a statutory power. Any standard book on law of limitation like Rustumji, Mitra, they say like this. So, though section 21 prescribes the limitation of 1 year ordinarily, sometimes 1.5 years, 6 months for passing order, if no order is passed, the tribunal has power to entertain the petition application, even if much delay beyond that period also. So that implies power to condone delay, number one. But for review, as learned the council pointed out, there is no provision for condonation of delay because section 5 is not incorporated in that. All right. We will go now as the interpretation placed by a coordinate bench of this court. Even if we go by that, the unexplained period of 4 months, sandwiched between passing of the order and your approaching the writ court. There is no application for condonation. There is no prayer for condonation of that delay. That you should have explained. Court said the period in prosecuting the petition, that is liable to be discounted. Beyond that, it did not say. The tribunal did it. The tribunal says, no, I cannot condone delay because no explanation is offered for this sandwiched period. What is wrong with this order? You are not some person from rural area, land cultivator, or a person belonging to downtrodden communities, etc. You are Union of India and you have made the legislation. You are the lawgiver. Lawgiver is bound by the law he gives. Which is that legal remembrance versus it applies to you.
The prayer was for condonation of delay of the entire period.
Where is the explanation?
That I will produce.
You will produce. You will see, you show your application.
It is not.
Then you are dismissing the petition. We don't do things on installment basis. The problem with this court is you are all intelligent people, but you do not read and come here. You are all intelligent.
I'm sorry, I could not prepare it properly before coming before your lordship. That is, your lordship, allow me some time. I will.
With cost, we will give time. You give 2 books to the library.
Right.
One limitation.
Okay. Which book you will give?
On limitation.
You give on limitation, Rustumji. Learned Council, CGC, Senior Panel Council. So that Senior Panel Council appearing for the Union government, having argued the matter for some time, seeks a short accommodation to come out with more preparation, matching to the requirement of the case. First, ideally speaking, he should have prepared the case and started argument. Or at least for that purpose, he should have sought for adjournment initially. Which he has not, this he has not done. First, next, in the above circumstances, a short adjournment of 2 weeks is accorded, subject to the rider that the petitioners shall present Rustumji on Limitation Act, latest edition, to the Bar Association library, within 10 days. Within which the petition runs risk of dismissal Otherwise, they will not pay. For that, again, contempt, etc., etc. Yes.
Item 15.
Wait, please, my lord. In this case, my lord, I am challenging the order at Annexure 1. Yes, will kindly see page 21. The case, my lord, 2006, my lord, that with 2008, my lord, that as per the 6-pay commission report, my lord, that the rule came into force. Revised pay rules came into force. Rule 7 of the pay rule says, your lordship will kindly come to, I have annexed that rule, my lord.
Page,
lordship will kindly turn to page 67. Sorry.
like the 5.
Yes, 67, my lord. Lordship may kindly turn to page 67.
No, our page, we may not be on same page because the registry has not renumbered price.
Page 67.
Exam.
Page 67 of the repection.
That Gazette of India Extraordinary.
That Rule 7, I'm just placing before you, Lordship, my lord.
Fixation of initial pay in the revised pay structure.
Yes, ma'am. Fixation of the initial pay in the revised pay structure. Lordship will kindly come to page 64, that capital A.
Which page you are referring to? Which page you are referring to?
Page 67, my lord. Running page 67.
Yeah.
Rule starts at 67. Now you will estimate the relevant provision that is at page 68, my lord.
Yes.
This speaks of the formula, how that pay is to be fixed, my lord.
A.
Capital A. In case of all employees, that means existing employees, my lord. In the pay band, stroke pay scale will be determined by multiplying the existing basic pay as on
1.86.
As on 1/2006 by a factor of 1.86 and a rounded off the resultant figure to the next multiple of 10.
Yeah.
The Roman 2, if the minimum of the revised pay band oblique pay scale is more than the amount arrived at so the pay shall be fixed at the minimum of the revised pay band oblique pay scale. Now, provided further that, my lord, where in a fixation of pay, the pay of the government servants drawing pay at a 2 or more consecutive stages in an existing scale get bunched. That is to say, get fixed in a revised pay structure at the same stage in the pay band, and then for every 2 stages so bunched, benefit of 1 increment shall be given to avoid bunching of more than 2 stages in a revised running pay band. Lordship, my lord, you will kindly turn to.
What is meant by this?
My lord, one second.
You have read it, but you explain it to us.
Yes, my lord. Yeah, this provision itself says, my lord.
This provision, it's an exception to the rules.
No, it is this has been provided by way of addition, my lord.
Not provision.
It says, my lord, you may kindly see what it says, my lord, as I understand, my lord.
1 second.
Normal pay revision is to be made.
1 second. Go to A. In the A, small Roman 1 and 2
yes,
are the rules. Proviso is an exception to the rule. 53 Supreme Court.
Yes.
Therefore, you should first show your case fits into 1 or 2. Then you should travel to the proviso.
Yes.
Show it now.
Now let us apply.
Let us apply 1. 1 is your pay as on 1/1/2006 multiplied by 1.86.
And rounded up.
Rounded up to next 10 will be the.
That is so. This is first one.
Yes, ma'am.
Second one. Suppose applying the rule 1, if we arrive at a figure X, then we travel to rule 2, where applying rule 2 will be x plus y, then you are entitled to x plus 5. Suppose by applying that rule, your pay is x minus y, then you are entitled to retain x. Correct?
Yes.
So that is how the bunching is done.
That is how it is done.
My lord,
Now,
basic principle is apply A1, AI. If the amount arrived at becoming below a amount which is prescribed as a minimum of the revised pay, then the pay will be fixed at the minimum of the revised pay.
Right.
This proviso says, while doing so, if an employee, supposing one employee has worked in that on revised scale for more than 13 years, and thereafter he is coming to the revised pay, then in that case, according to that AI, after applying AI, up to 7 or 8 stages, my lord. In this particular case, my lord, in case of this inspector post, my lord, up to 8 stages, their pay was fixed at 17,140. Applying Formula 1.
17,140.
That is the basic they have granted, my lord. That is the minimum.
Clause 1.
After, yes, applying clause 1, they were 5,500 to 9,000, my lord. After applying clause 1, up to 8 stages, my lord, they did not reach to that minimum of the revised pay. Therefore, applying clause 2, that minimum of the pay is to be given to them. This gentleman was working at the 11th stage. That proviso says, in that event, to give that proviso gives a benefit to the senior persons. Otherwise, while a person working at the 8th stage, 11th, up to 8th stage, will get the same pay which is granted by a new entrant. Lordship will kindly, to appreciate my case, my lord, Lordship may kindly come to
consideration.
Now, my lord,
who will issue notice?
Beg pardon.
We agree with you. For the time being, subject to what he will say. You accept not? There is an arguable case. At the 8th stage, he was getting 17,140. But he at the 11th stage, what is the position? Otherwise, you will be equating the pay of this man to the pay of the fresher who gains entry to the service. That is discriminatory. Yes,
that's why the rule says for 2 of them, we used to get one more.
We examine.
Yeah. Heard learned counsel appearing from the petitioner. One petitioner. Petitioner. First, a case is made out for issuing of notice. First, issue notice. First, learned. Are you CGC? CGC. Learned CGC. So and so. Accepts notice for OP numbers. All OPs.
Yeah,
all OPs. First, matter lays in a narrow compass, and therefore, all the same. After 8 weeks, first, in the meanwhile, counter if any, maybe filling which right stands for thinking. Next.
Item 16.
Nay, please, your lordship, madam. The appellant being convicted, madam, in inside custody since 23/10/2010, madam.
What is for?
302, madam.
This is for bail.
Sorry, madam.
This is for bail now, today.
Yes, yes, madam. Now 15 years and she has not been released on bail.
Can I report?
Custody certificate.
Custody certificate, antecedent, and report.
Obliged.
Item 17.
May I please, your lordships.
Lordship's appellant has been convicted under section 376 to FIK and section 6 of the POCSO is there. So notice, Lordship, one small prayer, Your Lordships, the CA report and
notice as well as all for a report, CA report and conduct certificate and custody.
Item 18.
My lord. In this case, my lord, the surrender certificate has already filed, but that is misplaced. Kindly have this surrender certificate.
He was earlier he was released.
My lord.
You are producing surrender certificate.
Sir,
was he earlier temporarily released?
Filed, but that was missed in office or somewhere.
You was released on interim bail when?
Interim bail already granted and I have surrendered in time.
When the interim bail was granted?
Really give attention to what the court is asking.
When the interim bail was granted to you?
Not talking with the great. Why can't you bring a small chip, palm chip? You're writing everything. Coming here and turning the pages of the pages. Wasting time of the court. April 34, 2025.
3425.
For a period of 3 months. Within 3 months, have you surrendered?
Yes, madam.
Pursuant to the order 35. The appealant convict was admitted to 3 months interim bail. The petitioner has, the appellant has now placed on record the proceeding dated 11/8/2025 before the additional sessions judge Puri which indicates that after the completion of the interim bail period, he already surrendered. The proceeding is taken on record, release the matter for final hearing up to 2 weeks.
Item 19 has been adjourned. Item 20.
My lord, are you getting bail, my lord? I have filed.
Clear it because the combination is clear.
20, I am in BC, my lord. Last occasion, State Council is directed to obtain regarding the service of notice, my lord.
More time to obtain instructions regarding the service of notice.
My lord.
Yes,
my lord, they have not received that. Letter has sent, but we have not received the received.
Service of
service of the notice.
The informant is not yet been. The order is 7. When was the direction was made? By order 13 to 2025. The State Council was directed.
13 through 25.
25.
11 months are almost 10 months are over now.
The State Council was directed to serve a notice on the informant of the victim. So that the interim bail, so that the bail application moved by the convict should be heard. However, the service on the informant victim has not yet been ensured. The letter council for the state seeks 1 more week to ensure that the service on the respondent, service on the informant of the victim could be effective. Release the matter after 2 weeks.
Well,
last opportunity for the State Council to ensure that the service on the informant of the victim. Yes.
Obliging.
My lord, the appellant petitioner has been in incarceration more than 5 years. He has been convicted under section 302 of IPC for commission of a murder of one Arjun Raut. my lord, the genesis of the occurrence aroused out of a fiction-ridden group, both the parties, fiction-ridden group belonging to different.
Who is the eyewitness?
Pardon?
Who is the eyewitness? This is for final disposal or bail?
Bail.
Tell the who is the eyewitness?
Pending like the appeal.
Eyewitness. Who is the eyewitness?
Yes, yes. Lord,
PW?
PW 11, 13, 14 and 20 are your eyewitness. 11, 13, 14 and 20.
14 and 20. Doctor?
Doctor PW 9.
9.
Read one of the eyewitness. Let us read 13.
11.
The best eyewitness according to you.
My lord. PW 11, my lord. I know the informant who is my nephew. I know the deceased Arjun Raut who is my brother. I also know the accused Panchanam Das, the present petitioner, alias Guji, of this case, and other accused person, namely Bhagirathi Barik, Manoj Barik, all the accused person in the split of trial. The present petitioner has the trial in the split up. He was the abscond of trial.
But one wasn't trial.
It's all right. Read it.
The occurrence took place on 8 p.m. on 18/4/2014 near the house of accused Bhagirathi Barik. While was sitting in my veranda with Tima and Uncle Pranab Raut, my daughter-in-law called to take my dinner. I heard a commotion about killing of Arjuna Raut and rushed to the spot and found accused Vibhuti Barik, Manoj Barik assaulting Arjuna Raut by means of sword. Manoj Barik was assaulting by means of Bhujali. Accused Panchanam Das, the present petitioner, assaulting by means of Thenga. When I intervened, accused Bhikari Barik assaulted me by means of an iron rod on my right hand.
13. Thenga blow in which part of the body?
Not. Yes, this is
which part of the body?
Is it on the vital part?
Assault.
You just so Thenga blow, he was armed with Thenga.
Yes.
He has given a blow. In which part of the body? And corresponding injury?
PM report.
You saw from PW9.
PW9, my lord.
Yes.
Vital organ.
Second, how many injuries there will not be?
PW9, my lord, page 91 of the paper book. On 19/4/14, I was working as assistant surgeon DHS Kendrapada.
Come to the relevant part.
Yes, my lord. External injuries, one laceration of size 6 cm into one cm on scalp.
Extending to temporal area.
Laceration wound. This is by the Thenga, my lord.
Which one? Laceration.
Number 1.
Laceration.
So the Thenga blow fell in the forehead, so something.
The
head injury. This head injury.
Yes.
Head injury is caused by him. You saw us. That's all.
The accused Panchanana, alias Guji, assaulting by means of Thenga, who is part of the body PW11 has not mentioned, my lord. PW 30. My lord, PW12 stated that Panchanana alias Guji dealt a blow on the head of my father by means of Thenga.
Okay.
That is corresponding injury?
Yes. Yes, Mr. Das.
My lord, I bow down to lordship, but that witness has not been examined by the police. They are cross-examination.
It's different. You are not arguing the appeal now.
That's one thing. But
we don't.
My lord, my humble submission.
You have to know is the cause of death.
Cause of death. My lord, when
head injury.
Head injury, but in the cumulative effect, doctor has said
maybe
the cumulative effect. My humble submission.
Case for arguing on appeal.
That I down.
When the
threshold, I must demonstrate that there is a perversity in the finding, pointing to my attributing to me. When
you can argue at the stage of arguing on appeal.
For bail,
we can't have such a.
Similar, I am demonstrating. I am demonstrating.
Tell us the date when you can argue the appeal.
So there are other accused persons.
So therefore, there are many.
Even if I will be prepared, your lordship may not, because other
They are separate officers.
We are not rejecting your application.
One thing. Otherwise, section 34 is there. So what one does is attributed to the rest of the people, even if they are mute spectators.
That's understand.
Barindra Kumar Ghosh.
The learned court has convicted by applying 149.
Applying 149 is not invoked.
No, 149. 149. Because for being a member,
common object.
Unlawful assembly.
Unlawful. Therefore, Millard, when all the eyewitnesses conspicuously silent about the assault by me on particular on the
we are not rejecting your application. Simply adjourning it after 2 weeks. Get ready with the final.
Another. But one more. Millard, all the witnesses.
Custody period is not much.
No light. All the witnesses said there is no light. There is no light. Millard, when all the witnesses said that the incident occurred in the dark, dark, and this Pratap was not examined by.
You want a rejection now?
Liar.
4 years. 4 years only.
No, 5 years.
4 years.
Another Millard.
Appeal is 24. 24 appeal. 2024 appeal.
I'm incarcerating for 5 years and I was on bail. That is right. I was on bail, and one of the accused who was pioneered the incident, entire crime, he has already been granted bail. Interim after
2 weeks.
Lords, in item 21, which Lordships heard.
There is one time bound matter. 45 some order. 45.
Yes.
There are sub items, Lordships.
My lord, item 23. Two matter next week.
43.
23.
26.
Prisoner person ala.
Okay, we'll see next week.
23.
Yes.
Item 45.
Yes. 43, 45. Yes, sir. Please, madam. Yes.
I am for the Union of India. The Union of India has filed this writ application.
You are on that side, no? Which side is the petitioner? This side is the petitioner. No, petitioner side. Petitioner side. This side. Okay, so we go to that side. Please, madam.
That side.
Anyway, here.
The Union of India has filed this writ application, my lord, challenging the order of Central Tribunal, my lord. The order is at annexure.
What is the subject matter?
Subject matter.
Say in a few words.
The opposite party, my lord, the opposite party, while working under a project, IDVC project, subsequently permanently recruited as a scientist after due selection process. And after retirement, he has filed the original application before the tribunal to count those periods served in the project for the pensionary benefits which has been allowed by the tribunal, relying on the two judgments. But so far, I have filed the judgments which refers to Madras High Court, same case where my lord, the prayer of the similar situated person has been disallowed.
Madras CAT.
Madras High Court. And subsequently that was confirmed by the Honorable Supreme Court also.
Identical fact matter.
Identified.
He was also scientist only.
He was also same scientist, same. He was initially working under a project for a specific period. Subsequently, after the recruitment process, he has been resigned from the project and recruited in the post of scientist. He had retired from the post of scientist.
I can recall.
That matter.
Tender resigned and joined, whether that is a technical resignation or not.
Yes,
If
yes.
it is a technical resignation, the past service will be counted for the purpose of regularization. And the tribunal says it is technical resignation, and tribunal relied upon the judgment of Madras, Chennai, and the Delhi High Court, and which is confirmed by Supreme Court.
But those cases are quite different because there might be no post.
That is the only thing. So that whether it is technical, whether the resignation is technical or not, so that part. If
That
it is
also my
technical,
lords had
then
examined on the
so
last
it is
date, page number 41 and 42 of the writ petition, where at the time of joining, technical resignation was submitted and it was accepted by the respondents. On their accepting, I joined the regular establishment.
What was the gap between these two?
There is no gap, my lords. I submitted my technical resignation today afternoon and I joined the new post tomorrow forenoon. That is the...
So the resignation letter.
For the resignation letter, my lords, is number 41 of the writ petition.
41. So the resignation.
Yes, my lord. In fact, my lords had specifically examined this aspect.
Yes. Read it out.
My lords may see.
Joining for the post also. Selected the post also.
My lords may see page 41.
Yes. May join.
I have been selected. Kindly see, my lords, the wordings of this letter.
Yes.
I have been selected to the post of Senior Research Officer, National Institute of Malaria Research, Delhi, on a pay scale, on a pay of rupees so and so, with a council's letter number so and so, dated so and so. I have joined my duties on 16th March 2007 forenoon at IDBC Ranchi, as I am already posted at the field unit and acting as officer in charge. As such, my joining may be treated as deemed. This is my joining. My resignation is at page number 42.
42.
Yes, madam. This is to the director. Madam, may see, there was a vacant post of SRO at NIMR Delhi, for which advertisement was made by the council. I have applied for the said post, which was duly forwarded by the director NIMR Delhi to the Director General ICMR Delhi. Since I have applied through proper channel,
it may be treated as technical resignation.
It may be treated as technical resignation. And that resignation was duly accepted. Thereafter, I joined on the very next date. Today, and this happened in which year, my lords? 2007. 2007. And today in the year 2025 or 2026, it is not open to you to come and say that an action which took place in 2007 on the basis of a technical resignation is not a technical resignation.
Where is acceptance?
My lord, the acceptance, after the acceptance, my lord, only I joined at page number 41. The page number 41 of letter which I have written is the very next day. My lords may see the 42 page order letter is 15th March 2007 and this letter is 16th March 2007.
But not even a day.
In the service jurisprudence, my lords knows that the services are counted according to forenoon and afternoon. If a person has demitted an office on afternoon and joined in the forenoon, then there is no break
at all.
Then there is no break, my lords.
Then that's the only question. If it is technical resignation, then that the past service has to be counted. And
Am I not their own office member and not so?
Let them complete the letter. Here is the case. The same thing again I am repeating. We have not given any sort of acceptance that he is continuing earlier post and joining a press post. We are saying that a person is working in a spare capacity in a project. Now he is regularly selected a post. He is a permanent nature.
Correct.
Those persons he is working prior to this post, he was in completely temporary nature, and from that post he is
trying to carve out a exception to the people those who are working in project.
Project.
Not be given the benefit of what you call the technical resignation. That's what you are saying.
According to my learned friend, he is saying that the others are being regularized. Yes, we are accepting they are regularized. But for the same post, this is not this is a post he is going to be joined and this is promoted in
the same post, anybody will resign and join.
But because he is selected and they are not getting any scope for promotion, they are not getting any scope for other benefits. Only we have observed based on the direction of the court on the same by supervision of the posts. It is not that there is a post we have observed there. Based on the direction of the court, because they are temporary in nature, they are working a long period.
How long they had working? He has worked.
In the project matters, 19 years and 2 months.
That's why those post peoples are already observed and they have served for a long period. They have given only regularized and they have treated as a regular. They are retaining the same postal.
No, the project is under what? The project is under?
The project, my lords, is under the National Institute of Malaria Research.
Okay.
There is a project called IDBC project. This, my lords, this is a project created by the then Prime Minister's office at that particular point of time for eradication of malaria and vector-borne diseases in India. Initially, it was a temporary project which continued, my lord, for the last 70 years. It has been continuing like this.
You are working in that project.
I am working in that project, and my lords may kindly further take note of this fact that the selection was made not by any project. This project is not independent of NIMR or independent of Government of India. The selection was made by NIMR. The appointment was made by NIMR. The appointment was made on the conditions applicable to the central government employees. The pay scale was given to me on the same analogy as that of the central government employees.
Regular pay scale.
The regular pay scale. It is not consolidated, the regular pay scale. And then, my lords, CCA rules, CCA leave rules, CCA medical attendance rules, CCA leave rules, everything was made applicable to me. And my lords, at that particular point of time, had I committed the criminal offense, then second say that criminal IPC 197, all these things would have been applicable to me.
Sanction and all.
Today, everything is required. Today, my lords, and rule 13 of...
You are saying for all practical purpose, you are regular employee.
I am and my lords, I was not the only person who was appointed in the project. There are hundreds of other employees who were appointed in the project. And all of us went to the...
What is the difference between Madras case and this case?
Madras case. My lords, may straight away come to the Madras case, I will point out. My lord, as far as the IDBC project is concerned, the first judgment came from the Madras tribunal only, which was upheld by the Supreme Court. Thereafter, all the persons who were working in the IDBC project were regularized with effect from the date of initial appointment, and the period which they have spent in the IDBC project from the date of their initial appointment till the date of regularization has been specifically counted for the purposes of pensionary benefits by the respondents themselves. All those orders I have put on record. Not the
difference between Madras judgment,
yes,
which came to be affirmed by the Supreme Court in SLP, and your case.
First, my lords, this Madras High Court was not cited before the learned tribunal. This point was never taken before the learned tribunal. And secondly,
Madras judgment is in your favor.
First Madras judgment on which is applicable to the IDBC project. That is in my favor.
Yes. No, that is for regularization.
That is for regularization.
Yes. But here we are asking.
He is relying upon another He is relying upon a judgment called Samuel Johnson. My lords may straight away come to that judgment. I'll point out only 3 things from that judgment, and then thereafter my lords may take a decision.
Page 216.
My lord, that judgment is at page 258 of the petition, my lords.
69, annexation 14.
258, my lords, according to me. Yes.
Whichever.
Now, my lords may kindly see
the paper pages.
First thing that my lords may see in that is
258.
Paragraph number 3.
30.
This is, my lords, the Madras High Court judgment. So therefore, wherever they have stated respondent, it was applicant before the tribunal. The case of the respondent.
Para 3 you are reading?
Para 3. The case of the respondent is that the applicant was appointed as a research scientist on consolidated amount.
We are not in the same. We are not on the same page now.
My lord, it is para 3 is at page number 261.
Philip Samuel.
Philip Samuel.
Philip Samuel starts at 258.
Yes, and I am reading at page 261.
261.
Yes.
269, annexation 14.
Let us go to the judgment now. We are not on same page. We will go to. What is that para number? Para number?
Para number 3.
No, 3.1.
261, 6 and 7 para.
3. In case of response.
71.
In according to our record, 272 plus
272. Okay.
271. My friend is at 271. Let's see, we'll find out on the 271.
I'm sorry for the difference. The case of the respondent is the applicant was appointed as a research scientist on consolidated employment basis of 3,000 rupees per month on ad hoc basis in a project entitled JE Control Trial Studies in South Arcot District. this is not IDBC project, number one. This is a local project in South Arcot, which
consolidated pay scheme.
And in a consolidated pay scale. Yes. Then thereafter, my lords, may kindly come to the next distinguishing factor, which is in paragraph 3.2. This project was closed after short time. In pursuance to the above said order, the respondent have passed a speaking order dated 26/5/2022 by informing that the request of the applicant to count the past service rendered under the project could not be acceded to, as there was no rule position to support his claim. In my case, my lord, rule 13 of the CCS pension rules is there. And number 3, my lords may see, the applicant was not observed as scientist B and he has been appointed as scientist B through direct recruitment and so and so. The claim of the applicant that he is eligible for consideration of a pensionary benefits for each service in the project could not be accepted, as the service rendered in the project is a co-terminus with the closure of the project. And thereafter, the tribunal, after taking into consideration of all the aspects, correctly dismissed the application. Therefore, the writ petition is liable to be dismissed. And then thereafter, my lords may see declaration of law which has been given there. Page number, paragraph number 5. Page 279. 275. Please. And I am, my lords, reading towards the middle of that paragraph, which says, which starts by the sentence, it is well settled law that. It is well settled law that. My lords have got it? No. Next page, my lords. Next page, about 6-7 lines from the top.
In para 5?
In para 5, my lords. Para 5, my lords, are in 2 different pages. It starts from the pre-page and continues to the next page also. And in the next page, my lords, top 7 line chhod dijiye, 8th line. It is well settled law that.
Yes, it is well settled.
It is well settled law that temporary or contractual basis cannot be counted for pensionary benefits, and the date of appointment as a permanent employee has to be taken into account. This is, my lords, in clear teeth of the judgment, 10 judgments which the learned tribunal has relied upon of the Honorable Supreme Court, saying that where a person, even if there is no rule for counting the past service, if a person has rendered continuously for a long period of a service followed by regularization, then in that case, that entire service cannot be wiped out for the purposes of a computation of a pensionary benefits. And this is the judgment, my lord, the 10 judgments which the learned tribunal has relied upon, starting from Prem Singh, S.N. Verma, and all those cases. Those are all cases where people are initially appointed on temporary basis or contractual basis, continued for a long period of time, and thereafter they were regularized, or by direct appointment they were appointed as in the permanent establishment, and they were denied pensionary benefits by the counting of past service for the purposes of pensionary benefits. And the Supreme Court said that you cannot do that. That would amount to exploiting the people on the absurd terms. All the judgments, 10 judgments, my lords, not a single word has been spoken by my learned friend on those judgments. And today, my lords, as far as this particular case is concerned, undoubtedly, my lord, my case is governed by the CCS pension rules. And Rule 13 of the CCS pension rules clearly and categorically say that if a person joins a regular establishment without interruption between his previous service and the present service, then the entire temporary service rendered before he comes to the regular establishment shall be counted for the purpose of pension. This has also been examined and relied upon by the learned tribunal to grant me relief.
Kindly come to paragraph 7.
Yes, my lords.
Read paragraph 7.
Paragraph 7, my lords.
Yes.
It is admitted fact that
it is admitted fact that the applicant was appointed in the year 1988 on contractual basis for the project, and thereafter he was appointed in direct recruitment as scientist on so and so. The petitioner himself admitted that he was appointed on contractual basis as in the project till 18/7/2013. Initially, the salary was on consolidated basis, and thereafter it was transferred to the pay scale. Though it was transferred to the pay scale, the temporary service on contractual basis cannot be taken into account for counting the period for pensionary benefits. It is well settled law that the temporary or contractual basis cannot be counted for pensionary benefits and the date of appointment as a permanent employee has to be taken into account. In this case, the petitioner himself admitted the employment of contractual basis, and again in the year 2013, he was appointed as scientist B through direct recruitment, and thereby he accepted the contractual basis and he has not challenged the same immediately after his regular appointment. Further, the petitioner was not appointed on absorption and he was appointed on direct recruitment. Therefore, the past service rendered by the petitioner on contractual basis cannot be taken into account for the pensionary benefits. This is, my lords, what my lords are pointing out.
Yeah.
Yes. The Learned Central Administrative elaborated it. This, my lords, is on the teeth of the judgment of the Honorable Supreme Court.
This went to apex court.
Yes, they go to apex court, that is lost there.
This went to apex court.
Yes.
And secured imprimatur of the apex court.
Yes.
And where is the defect in this?
Where is that?
Where is the defect in this?
My lords, I am pointing out. Firstly, my lords,
what is the factually different?
Actually, my lord, it was not the IDBC project. As far as my project is concerned, the judgments have gone up to Supreme Court.
Sorry, which project tends into insignificance? I have to tell that.
This is the local project, Arcot, South Arcot district.
Rupert Cross on precedent in English law.
Yes.
He gives two theories of finding out the ratio decidendi.
Yes, my lords.
The first one is Professor Wambach's test.
Yes, ma'am.
Where a decision is resting on one particular point. If that particular point is reversed, whether the judgment will be sustained or not is the first test. Because to say whether both the cases are on the same line or not,
yes,
we have to depend upon the theories of precedent. You have to cull out the ratio of Madras judgment.
Yes.
If that ratio is affirmed by the apex court,
yes,
that becomes the ratio for rest of the country.
Correct.
Because of 141.
My lords are absolutely right.
Yeah. Whether this X project or Y project,
yes,
is irrelevant.
Yeah. In that case, my lords have already read that in that particular case, there was no rule pointed out to the court that the period of a past service on regularization will count for the purposes of computation of pension. In my case, there is an existence of a rule, Rule 13 of the CCS pension rules.
Let us.
Yes, my lords. Lordship may see the Rule 13 of the CCS pension rules. This is
whether previous service,
yes,
means previous regular service or
previous temporary service. Previous temporary service.
Let us see.
My lords may have a look at.
Please read that rule.
That my lords may see at this is quoted in the my lords may have a look at page number 120.
How the rule?
Central, yes, central pension rules.
Give that rule. Read that. Read that rule.
Central pension rule.
Commencement of qualifying service. No, they are called CCS pension rules. My lord may have my lords have it in my lord's paper book at page number 120.
We have it.
Yes, yes.
120. Go to 120.
Yes, my lords. Page 120. One of the judgments has quoted it verbatim.
Go to 120.
My lords have got it. It is in the midst of a Delhi High Court judgment. And my lords may see paragraph number 27.
Commencement of qualifying.
Yes, my lords. Commencement of qualifying service. Subject to the provisions of these rules, qualifying service of a government servant shall commence from the date he takes charge of the post to which he is first appointed, either substantively or in an officiating or temporary capacity. Provided that officiating or temporary service is followed without interruption by substantive appointment in the same or another service or post. So therefore, my lords, in this case,
brother,
even if my service,
Mr. Paddy,
yes,
this was not adverted to by Madras High Court.
Because in Madras High Court, this was not applicable.
This is not applicable.
No, but this is CCS pension rules which is applicable to.
Then where is the parity between the two things?
My lord, I am just clarifying one. Initially, the petitioner was appointed in the scheme oblique project. Let's say
that we agree.
Yes. So he has worked for a long period. There is no dispute at all.
Yes.
But basing on this, but basing on the orders of the Honorable Court, these posts, though were in temporary nature, have been superintendent post has been created. They have observed the similar status of the post, not in the above post. The person concerned who joined in a new post, giving application page 41 and 42, Lordship may see, in that page he has in my accepted, the no acceptance letter. Because there is no question of acceptance letter will be issued by the department. It is a complete and temporary in nature. Yes.
He gave a letter of resignation.
Yes.
And in the letter of resignation, in the last line, he said, using the expression, technical resignation. It is there.
But which can be achieved? Yes.
1 second.
Sorry, sir.
Then you accepted, you are deemed to have accepted the resignation because there is a letter which says you have accepted that you was permitted to assume the charge of the regular post. Take out Sudhindra Rao versus State of Karnataka.
But let's see DUPT circular. Yes.
Law relating to resignation.
Yes.
Colonel Nilendra Kani. It says, for constitutional courts, sending a letter of resignation is resignation. It need not be accepted at all. Then, in the case like High Court judges, Supreme Court judges, Election Commission of India, so many other people. In the case of non-constitutional positions, resignation will take effect after it is accepted by the employer or by the competent authority. Correct. Communication of acceptance is not required. That's the take out Sudhindra Rao versus State of Karnataka. Take out that Sudhindra Rao. Then he
may refer one page, my lord. It is they are also refer to.
Your entire argument is only one argument.
Yes.
What you are saying is the technical resignation which he offered cannot be treated as a technical resignation because he was not a regular government employee.
Yes.
That is what the only ground you have.
Only ground we have. Number one.
Counter that, what he says for all practical purposes, he was a government employee because CCS rule and everything was applicable. There was a scale and all. He was working in the same project. He resigned on 15th in the afternoon and next day he joined. Yes, so there will be.
And I joined where, my lord? I joined in the same office, same table, same chair, same subordinate staff, same everything.
No, that is completely denied by us because a person is joined into 88 onwards and he was in a particular project. Suppose, for example, I am giving in Raulkela there is a project.
No.
It was complete. Sorry.
Sorry for interruption.
Yes, sorry, sir.
Kindly come to rule 13.
Of the CCS rules.
The one which was read out.
Yes.
From the Delhi High Court judgment.
The rule employs the terminology.
Temporary also.
Not only that one, even service or post. Your argument is structured on the premise of post. But rule admits service also. Service is different, post is different. Kindly come to paragraph.
Once again I am reading.
Yes.
Subject to the provisions of these rules, qualifying service of the government servant shall commence from the date he takes charge of the post to which he is first appointed, either substantive or in the officiating or temporary capacity. That present post, my lord, not in the previous who is working temporarily.
Go to the next.
Yes, provided that officiating or temporary service is formed without interruption by the substantive appointment in the same or another service
or post.
Or post.
Yeah.
Provided
You want this part of the rule to commit suicide?
No, my lord. What I am submitting, my lord, those persons, those have regularized or he has temporary status or the regular status, whatever may be, they have working in a previous post. And he
post service also.
Services also.
Why it is so fancy?
My lord.
In the same or another service or post. Suppose if it is in some other service.
Neither same department. Neither it is service or post in the particular project is working.
No.
Yes, he is working with a particular project. Lordship may see the appointment letter annexure 2 onwards. Annexure 2 per a moment, Lordship may see. That is page 32.
In NIMR, there are many projects. But even during that pandemic time, these people started working in all the projects.
The project is complete. In Raulkela, we have published a particular scheme, they have gone to the address to Ranchi.
If you treat the scientists like this, they will run away to some other country.
No, my lord. We are very conscious.
I am sorry to say this, but this is demonstrable by record. Subramaniam Chandrasekhar, who worked out the black hole theory and was awarded Nobel Prize. He was treated by the same way in good olden days. That led to his going away to America. And there he was awarded Nobel. He was not treated. He told, I am a scientist level person. Give me a lecturer post. And none of you gave that. He went to America. There he got the Nobel Prize. Unless, he is not some FDC. He's a scientist. Yes. When Israel was founded, Ben-Gurion, the Prime Minister of Israel, begged all people, all intelligent people should come and reside on Israel soil so that the soil becomes fertile and nation will grow. How you are treating the scientist?
The long and short of the story, long and short of the story is, my brother is asking whether you want that he should get Nobel Prize or he will continue in your service. What do you want? That's what he says. If you want that he should get Nobel Prize, let him go.
Crux of the case crux of the case is that the old pension, new pension.
That's what.
They say only thing is this.
All right, come to para 20, page 28, para 11. What is the reasoning given by the tribunal?
And tribunal did not have the advantage of rule 13 because 13 was obviously not applicable to that case.
That Madras case, yes. That was a South
Court founded. And the Madras judgment came to be affirmed by the apex court because one important factor namely the invocability of Rule 13, was never discussed. Therefore, Apex Court said, yes, we agree with the judgment of Madras Court. But here, one important factor is Rule 13, which employs the terminology. The term is service or post. Similar or elsewhere. But suppose you needed to be an FDC, SDC, or some Pune, etc. We would have agreed with him. He's a scientist. Yes. He has worked for 19 years in the.
That's why we've given promotion, we have given all sort of service benefits. Thereafter, he is retired in the higher post. Not the person who those are acting in the lower post. He's the research scientist. He's not working that.
Have they given me the promotion without having seen any merit in me?
My lord, those persons
have been given departmental promotion committee.
Not coming. Lasime, come to the page 32, annexure 2. That is the appointment letter. Lasime see first line.
Your first contention is what? Just will articulate that. Give dictation. Give dictation. Right now, he's for the time being, he is sitting here. Right now. You articulate the point.
Well, my submission.
No, you give the dictation. We are praying. Give the dictation to our strength.
I'm not that side.
Dreaming is there. So, what is your first contention? I will write down.
My first submission to my lord is that he's joined in the post.
Yes. Now
in a project.
Petitioner joined the present post. Present post or project post?
Project post. He is appointed the technical officer. Technical officer on the research project mission on integrated control of malaria field station. There is a particular project was given in government of India.
You are not articulating the point. What is your contention?
My contention is that he is not in that post. He was initially a technical officer.
He need not be in that post because Rule 13, therefore I agree your attention.
Yes.
It says service.
My lord, may I pray, my lord, then? Let's keep it to any other because
party has argued very well now. In one paragraph will say you're very passionate.
My lord, Lord, I should pay to the court and transfer to the court because it is my
discuss on the following. Number one.
Another issue I'm just
applicable to of CCA.
CCS pension rules 1972.
1972. 72. Reads as under. It employs the expressions officiating or temporary service followed without interruption by substantive appointment in the same or another service or post. First, the text of this rule is very expansive and it is made with a particular object of giving the benefit of past service, though not in the post, for the purpose of computing the terminal benefits after superannuation. First, this rule was not the subject matter of Madras judgment, arguably because rule itself was not applicable. First, therefore, the ratio decidendi of Madras judgment is not applicable to this case when a very important factor is conspicuously absent in the Madras judgment and demonstrably present in the case at hand. First, it was Lord Halsbury who said in Quinn versus Latham, 1901, House of Lords, so 459, that a decision is an authority for the proposition actually laid in a given fact matrix of a case, and that it is not matrix and not for the logical extension of the same. First off, it hardly needs to be stated that one small textual difference in the rule position may make a C difference to the case. First, therefore, no milk can be drawn from pressing into service the decision of Madras High Court.
Someone, Philip someone.
Philip somewhere.
Philip somewhere.
Next point. We are taking a case of a scientist and not of a mason. First off, the case of the employee, OP number one OP. Only one. OP broadly fits into the contours of Rule 13 mentioned above. First off. Next point. Even otherwise, whatever little difference in the fact matrix of the case at hand may not render the Madras High Court decision applicable to it. First off, the tribunal in its accumulated wisdom has rendered the judgment which accords with the legal positions in service jurisprudence and therefore does not have any demonstrable error apparent on its face. First, next time. The vehement submission of Mr. Padi, learned ESG, that it is not a case of technical resignation, and more particularly when there was no acceptance of the said resignation, is liable to be rejected. And reasons for this are not far to seek. First, the resignation letter dated, what is the date of?
The resignation letter is dated 15th March 2007.
15/3/2007 at annexure? Annexure.
At annexure, my lords, annexure 6.
Annexure 6. In the last part, specifically states.
Annexure 7, sorry.
Specifically states that it is a technical resignation. First off, the letter of
joining. Yes, that is at page number 41.
Joining.
Annexure 6.
Annexure 6 gives only one that the petitioner's resignation was accepted, and as a consequence of that, he was permitted to join the post in question on regular recruitment.
My lords, my right is that without any interruption on the very next day. Yes.
It is noteworthy that the OP gave up the earlier position on 15/3/2007 forenoon. No, afternoon.
Join in court.
And joined the regular post
in the next day.
on the following day, that is 16/3/2007 in the forenoon. Thus, the gap is not even 24 hours. And any gap sought to be made out by argument is fictional. Is fictional. First one. The examination of the matter at the hands of this court is under Article 227 of the Constitution, notwithstanding the ornamental employment of Article 226. First one. This is a supervisory jurisdiction, and such a jurisdiction has traditional limitations which do not permit the court to undertake a deeper examination of the matter, as if what it is examining is an appeal over and above the impugned order of the tribunal. Yes. Any other point you want to say? Yes. Yes.
But should my lords incline, my lords may mention somewhere that after his resignation on 15th of March 2007 and joining on 16th, it is the same office, same chair, same table, and same subordinate staff, same everything.
Learned senior advocate appearing for OP is right in telling us that the new post which his client has been appointed to and reported for duty is the very same post.
Same office.
In the same office. And with the same table and chair.
Same table, chair, same subordinate staff, same everything.
Therefore, in such a case, the fictional difference which Mr. Paddy wants to create by his ingenious argument is liable to be ignored.
Please, my lords.
See lawyer also.
Please, my lords. I'm obliged.
Surendra Rao versus Noel. So, just give that and the affirmation by the apex court, that particular act.
Nothing reflect along with me, Mr. Bhokta is also.
Sorry. The body along effectively assisted by CGC.
Please, my lords.
Yeah.
Item 24.
24. 24.
Yes, sir.
Make present. Since the last order, my lord, this is interviewing. This is like 302 conviction.
The petitioner was directed to release on bail, interim bail, and my lord directed to obtain the conduct of the petitioner while he was on interim bail. That report I have not received, my lord.
When you were directed to receive it?
In the first, when he was released on bail. In the
on
18/8/2020.
Yes, yes. During that
the other matter we saw, 10 months were over and you have not secured the information. Why is the difficulty?
Well, during that period, police has to watch over his conduct. Thereafter, after surrender, police has to give the report, my lord.
I surrendered.
Is required.
Yes, that period.
I surrendered on 21/11/2025.
So after
one week,
after overall
expiry of the interim bill.
After the expiry of the interim bill.
Let him get to. Yes.
Next week,
On request of state council. To service.
Item 25.
Note by Honorable Chief Justice. What is the note of Honorable the Chief Justice? It's not suitable. There is note of Honorable the Chief Justice. What is that note?
Flag C, Your Worship. There is a flag C.
Where?
Flag C,
What is it?
the last one.
What?
2024.
Which one you have called? Yeah. In the 25 only note is there, no?
No, the flag C is the regarding the roster. Regarding the listing of the matters, that's the flag.
Okay, this is a regular standing instruction.
Yes.
So by that instruction or dispenser jurisdiction?
Yes, Mr. Punda.
My lord, page 52, conviction under section 302 and sentence to undergo RI for 20 years. That's why
Kindly see the 2310 25.
that's why the coordinate bench has referred to the division bench.
Life Justice Krishna Thomas judgment means life imprisonment means imprisonment for life.
Rest of the life.
Is it the legal position correctly? That was 20 years ago. Any change in the position now?
Kindly see 302, the punishment prescribed.
Yeah, that's what my brother told him. It is I very often turn to him to learn so many things. I read one judgment during my student days.
Yes.
That life imprisonment means imprisonment for life.
For rest of the life.
Is it the
Yes,
is it the law?
Yes. That is the law, Your Worship.
Unless commuted.
Yes.
For commission of the sentence that has been treated as 20 years. Otherwise, it's the rest of the life. Your Worship.
Rest of the life. Because life is taken away.
Yes.
Recent judgments are so rest of the life.
The statute is clear.
Now this appeal is to be heard.
My lord,
Appeal is
and I may pardon, my lord, the appellant is 64 years. So during trial, he was on bail. And the only direct demand and the other things are there. No direct assent. So I pray one thing, my lord, custody certificate may be called for.
It may not be required. May not. You should kindly see the impugn order.
No, impugn judgment.
Let us see the order. 23, 10, 25 you say.
Your Worship, kindly see page 26 for him. 26 running page 26. We have the internal page of the impugn judgment.
What is there?
The period of detention has already been prescribed.
But the antecedent and the other
As Your Worship. As well.
bring them.
Next week, except 16 any day or one week after. As your lordship.
Some other bench will take care of.
We can't fix next week because we do not take of other bench.
1 week after medicine.
One bench is only for today.
I pray 1 week after medicine.
1 week after.
Me pardon, my lord.
And I pardon, my lord. Let me directly take instruction.
Yes, I am.
Yes. So blessed.
The item T may be called on 12. After launch, I will remain absent due to sad ceremony of my
What time?
on Monday, my lord. Electricity supply.
Next, can we post it next week?
Monday, my lord. Monday. Next week.
Yes, mentioning because they are getting up. Na? Next week, can we take next week?
Yes, my lord.
Definitely. The request.
Only my hearing of fresh admission, my lord, because I am without electricity, my lord. Fresh admission.
You appears to be electric power man. And powerful man also.
I was there, my lord. I was there once upon a time.
In the electricity department?
Yes, I was there.
Yes. So we don't give shock to us, that's all.
Yes,
Item
anyway.
28.
Next week.
Millard, Monday. Item 28. Monday or Tuesday? Item 28.
28. Yes. Urgent.
Yes, for next week. Next week means only 12 or 30 because from 14th I will go outside. Millard.
28 on request. Okay.
Because
it is other bench, we can't fix the date.
We can't
you
fix
know.
the date because
That's the
that
problem.
goes before the other where we are.
May not be there.
my lord is there.
Thank you.
Now, the present appeal is the challenge the judgment dated 23/4/2025 passed by the Lawrence District and Sessions of Niagara in order to convicting him.
This is for what? Final disposal? What?
This is for bail.
Yes.
That
You have custody certificate?
May not be required. Also, kindly see the impugned judgment that has been reflected. The recent judgment, so they have a column for internal page 2 and running page 15. So as on 23/4/25, this 4 year, 11 months. So maybe 5.5 years.
5.5
Yes. Eyewitness?
Yes, my lordship, eyewitness is there.
1, 3, 4, 5, 6, 7, 8, 9, 11, 13.
3, 4.
1, 3, 4. But 1.
1, 3,
1, 3, 4, 5, 6, 7, 8, 9, 11, and 13.
So many eyewitnesses.
My case is not based on that much. That my case, that present application, that nowhere the prosecution is established the motive of the present accused.
Eyewitnesses are there.
Ground for bail.
No, eyewitnesses are
Case is processing
4, 5, 6, 7 eyewitnesses are there.
Each and every eyewitness contract to each and every person.
When you will argue the appeal, then we see. Okay. Simply missed the appeal for hearing after 4 weeks.
Let's call the conduct certificate. Kindly adjourn the matter next week, my lordship.
Presume that you have.
I'm prepared better to satisfy my lordship. I'm prepared better to satisfy my lordship.
Yes.
Item 27.
My lord, in this case, can you see the last order? The state government was directed to serve some instruction.
In portions to the order, my lord, the state government has issued this notice to the special article because they are the employees of which High Court. On certain points.
Time on 8/12/2025 to secure some instruction. What is that? What was the instruction, Mr. Kasim?
My lord, this is with regard to grant of RSCP by calculating our past service. To get a revised under the benefit of the RSCP, revised issued
10,
period
20,
probation.
30.
10, 20, 30.
10 to
5-year service of ours has been totally eliminated. That is why, and basing on a circular, that government notification, finite notification has also undergone a change. That is why, my lord, kindly see my lord's order 14/11/25. There is an exhaustive order. Taking note of everything, my lord, have directed them to take the instruction in this matter.
This is 15, 25, 30.
That was further revised to 10, 20, 30, madam. So now,
where is the instruction?
They have, government has also sought for information from this Hon'Ble High Court registry on the certain points.
Getting information on these 3 years.
They have sought for this instruction from this.
When the order was made?
8/12. See, this matter has suffered so many.
Yes, my lord was.
So many others.
No, why are you not counting the previous service? On what ground you can wipe out 5 years of service?
That we have exactly submitted, Miller. So far this initial joining at the post of copyist, my lord, that in 39/2003. 39/2003.
This is entry point.
Subsequently, they have abjured a junior assistant
On
36/2008.
2003 is as copyist.
Yes, ma'am, copyist. On remuneration basis, ma'am. And so far the junior assistant is concerned.
Consolidated
That is, yes, that is on 36/2008.
In the scale, not in consolidated remuneration.
This is in the scale, my lord. 2008, it is in the scale.
Initially,
No, 2003 to 2008. That is the period which is now in question, na?
Yes, my lord. I am coming. Then, my lord, promoted to the post of senior assistant.
That is not this.
On 29/4/2011.
You have to say why you want.
I am coming, my lord. I am coming. So, if at all, so far the RSP is concerned, which is from 1/1/2013, that is 10, 12 and 20 and 30.
If that period will be counted, they will be entitled to RSP.
This is not in stagnant, my lord.
That period to be counted.
They have been promoted to the post of junior assistant.
Not promoted.
They have been promoted to the post of senior assistant in 2011, my lord.
2011.
11.
No, this RACP, as I understand in your state, is the service in the one post only.
If there is no promotional avenue,
It's a stagnant.
Say you have non-promotion.
Not promotion. But he has been promoted.
He has promoted.
No.
When he was promoted?
My lord, 29/4/2011 to the post of senior assistant. And within a span of 8 years, if at all it will be calculated since 2003.
Even if it is 39/2003, still he will not be entitled to is your submission.
Yes.
because you got a
promotion in 2011.
That
And
problem
in the meantime,
he's saying, my lord was.
Let us see the policy.
Yes, kindly see, my lord, page 23, Annex 6. That is the circular. That is undergone an amendment, modification. That is why.
15, 10 it is.
Yes, no, but initially, my lord, shall I read first?
10,
20, 30.
30.
My lord.
Now,
so now, from which date the 10th year will start? The initial date entry, that is the point, my lord. Whether 2000 or 2008. That is the only issue in this case, as I have understood. So now we have joined undisputedly as a copyist in 2003.
39, 2003.
Initially, we are in a remunerated copyist. That, my lord, you are saying that was in 2001. That is in a consolidated remuneration. We are not claiming for any benefit for that period. We have been brought over to the scale of a junior assistant, which is equivalent to that copyist also.
Yes.
So that is in 36, 2003.
39,
39, sorry. 39, 2006. Three, sorry, madam. So that is at Annexure 1.
Yes.
So now, what they have done, all these copyists, they were absorbed. Phase-wise, today also copyist is a regular post in this establishment under the rules also.
junior assistant.
Junior assistant.
Yes.
It is same scale, same grade. Same pay. Same pay.
The apex court in 74 SC 555. Lawyer powers state of
yes,
Tamil Nadu say, while adjudging whether posts are equal or not, pay scale is not the decisive factor.
That's correct.
Yeah.
We are also not that issue has also been resolved by another circular, recent circular. This circular initially under which RSCP has been granted to the state government employees, that is on 6/2/2013. The scheme came, Annexure 6. That was further clarified in a circular. That is why, my lord, in the last order, taking note of the new circular 13/2025, my lord have directed, now it is your position. They said in the counter.
Because they made a policy now.
Policy now.
Made a statement in Supreme Court in group of matter, where I was also there. They said that we are making a consolidated policy.
For everybody.
And 2025 policy you have brought.
Yes.
Whether they can get the benefit of 2025 policy or not. That's
the only point, my lord. That my lord have asked for.
You tell us whether in the policy he is covered, then we will dispose it up, saying that he is covered in the new policy.
That is the only
As
point.
simple as that.
Yes, sir. Unnecessary.
My lord, on that purpose, we have sought for this instruction from this special.
Your counsel has made a statement in Supreme Court, and now you don't have instruction. What is it?
Recently.
Why you are selectively getting instruction? You don't like this man or what?
No.
You made a specific statement.
There are 6 persons, my lord.
In a group of 200 matters or something. And the same instruction you furnish here.
Where from the instruction should come?
This is from the finance department.
Where is that?
Does
it come from Russia?
No.
Bhubaneswar.
That we have sought for. This is from the Home Department.
Home Department, not.
And on that particular point, there needs the clarification for which latest this.
Love litigation. That's what we gathered from. You don't want to give.
The statement which he made on the floor of the apex court. Yes. Is it referred? No.
May I submit one thing? I am for the opposite part number 2, my.
Yeah, I could.
For the special officer.
He is forwarding that policy.
Now the High Court and the state. Now they have 2 penal councils.
There are 2
separate penal councils. That is why my lord knows on the other day also. My friend has submitted a instruction that was not accepted by the government. That is why my lord have directed the state to give the instruction. Now he is
When will you get it, Mr. Monty?
Next week. My lord,
next week you will get that. Next week, finally.
Yes, finally. I have got that letter and communicated the same also. I have also handed over to the lower concern who has been.
Received the copy. I am for the opposite party number 2. I have received the communication today, my lord. The registry of this honorable court.
Give it. We'll dispose it up if he is forward.
No. Today I have received the copy just now. So what time is required to take instruction from the registry and submit before the court?
Or next week.
Next week.
In the meanwhile, the order dated 14/11/2025 to be complied with by securing the necessary information, filling which the information which is sought for may be deemed to have been furnished in favor of the petitioner. Have been furnished in favor of the petitioner. Yes.
Item 29.
Yeah.
Last occasion, my lord have directed to take the instruction that regarding the compliance of that driver of this order of this.
Yes, 23/4/2024 order. Learned additional standing council states in compliance of the order dated 3/4/24. He has received instruction and seeks some time to file the same by way of an affidavit. I have filed.
Is it annexed to
Have they filed the information now?
This last occasion, my lord have directed to take instruction and order of this annexer 5/9/2002 order has not been complied with regarding that issue of driver, my lord.
Which order you are reading?
My lord, annexer 5 is 14 of this repeats.
Last order you said, where is that order?
Last order is on.
Read it. That order is not there.
Order dated 7/1/26.
Nothing is there.
It's a request of Chief for this matter on 9th October.
My lord. Can you peruse the annex of 5, page 14? Then my lord can record that the way is disposed of is a direction to the collector Sambalpur to ascertain from the CDMO whether the applicant can be appointed against any unreserved vacancy at his.
Yes, sir. What is the information, Mr.
Millard? We have filed the counter stating earlier the details, Millard. So the backdrop of the case is, so far the Honorable Tribunal's order is concerned, they have disposed of the direction to consider the case.
There are 3 components in the operative portion of the order. Yes. Kindly read.
Page 15.
Well, that copy, yes,
Page 15.
page 15.
Copy.
The way disposed of with a direction to the collector Sambalpur to ascertain from the CDMO whether the applicant can be appointed against any unreserved vacancy at his hospital.
At his disposal.
His disposal. I'm sorry. The CDMO will give a clear reply to the collector within 1 month from the date of receipt of this copy of this order. In case he cannot be appointed by the CDMO, then he may be adjusted in some vacancies at the disposal of the collector available or anticipated, which is earmarked for the general category and which it is permissible to fill up, observing the economic measures imposed by the finance department. It is expected that it would be possible to adjust him in some post either under this collector or under the CDMO within 4 months from the date of receipt of this copy of this order.
Yes.
Yes.
What is meant by this order?
Yes. So far this post of driver is concerned, my lord. Admittedly, there was a publication. So far the appointment for the post of driver is concerned, my lord. They have been shortlisted.
Tell us whether you have ascertained the CDMO can give appointment or not.
My lord, this no available post is there. So for the UR categories, 2 posts are available, and this petitioner is found placed in serial number 3. So 2 of them have been observed as per the serial list come merit, and this 3rd person could not be observed for that bona fide reasons.
Yes, no.
This is now 51. Sir, Annex 8, page 18. While the content petition has been disposed of by the learned tribunal, now observe that they compliance report they find that since no vehicle was available and appointment of driver is no meaning without there being a vehicle. That is the last
from 2002.
Subsequently, government has made a notification not to go for this vehicle. They are saying it in the higher basis because purchasing of the vehicle, maintaining of the same driver, that has been changed, my lord, since 2000. That I have filed.
There are 12 sanction posts are there.
Since 2000.
There are 12 sanction posts are there.
I have filed also.
Vacancies are there.
Sir, I have already filed and in that Annex 8, page 18.
Miller, for the moment.
To say vacancy is there, but vehicle is not there.
Sir, that is the thing, sir.
Miller, let me clarify. B by 1 for my counter. For a moment, Miller. So for the transparency in the selection is concerned and belongs to your category, 2 posts were there. And this petitioner is found placed in serial number 3. Can you have a glance to page 26 for a moment?
No, this order is of 2002.
Yes, ma'am.
After that, how many vacancies arose? Why you did not accommodate to?
Well, total 7 vacancies.
In the last
yes, ma'am.
23 years.
Yes, ma'am. 7 vacancies. No, thereafter since
nobody has died.
No, nobody has died.
Nobody retired.
No, so far after retirement, they are not purchasing the vehicle and having. They have been outsourced and this is.
But posts are not abolished.
No posts are abolished.
This is Miller since 2015. Since 2015, Miller.
The policy decision is taken to abolish the posts. They have not held. Once retired, the thing automatically. Withering posting, wither away with the incumbent. We don't have any legal or contractual outsourcing.
So I have obtained under RTI.
You can accommodate him in peon post or something.
In persons to receive order, the CDMO has recommended to the other authority. You see that this person can be accommodated so far this driver post is concerned. That could not be possible also because of the non-availability of post. That I have taken the specific governments in the counter also.
You have taken up the contention that posts are not available.
Not available.
Posts are available, but vehicles are not available.
Vehicles are not available.
But posts you have retained. Have you abolished the posts?
Yes, Miller. Kind of a glance to page 61, Miller. The amendment rule 2020 regulating the control and use of government vehicles, Miller. delegation of power to the administrative department or
No,
function?
have you abolished the post? You have taken a policy decision to not to go for contract on contract basis.
Purchasing the vehicle and
easy or understand.
Yes, ma'am.
But what happens to the posts? The cadres and posts, they remain intact.
No, subsequently, there was no appointment since 2015.
Dying cadre.
Dying cadre.
You are saying.
No, I think
Unless there is specific.
Sir, they are those who are continuing, they will continue till their retirement.
No, but my problem is that.
Why then?
A dying cadre can't be automatically.
Unless there is a specific amendment to that.
To that. Doesn't die like that. Unless you.
Now we have produced some RTI information, wherein 7 posts are vacancies are
already I have given the details. It is at page 26. For a moment, it will clarify. Of course, they have not served the copy, but however, so far the 7 posts are there.
To an affidavit, I have already submitted it also.
7 posts are there, but vehicles you have not hired. Therefore, you don't want to appoint him is your contention. But that was not the contention before the tribunal.
But Millard, so far the 7 post is there. Kindly have a glance to page 26. I have clarified the details of the procedure. 26 of my counter. That is at B by 1.
B by 1.
Yes, ma'am. This is a proceeding of the selection committee meeting held on 3/31/1999 for selection of the driver. The selection committee comprises of these are the person vacancy position member. There are 7 vacancies of driver plus 3 post lying vacant in the following offices. These are the name of the offices in 7. Out of the 7, one Sri Bauribandhu Sau, driver, they
report for duty,
has been deployed by the RDC, Northern Division, Sambalpur, to Sambalpur district during the bifurcation of the districts, and he is yet to join.
Has he joined? Has he joined? This is on which date?
This is of 99 minutes.
Thereafter, this 99, thereafter the order is made in 2002. So presumption is all that is taken note of.
And thereafter, there was no such posting.
How can that be? So many people retire, so many people resign.
Because in 2000, since 2015, there is no question of purchasing the vehicle.
Okay, it's all right. 2015, 2002 order. 2002 to 2015.
This is the last appointment.
You can't say like that.
Let me serve the copy. So far, this RTA information.
Additional affidavit already filed.
Additional affidavit.
To an affidavit, I have filed my note.
Yes, 20 years he has been fighting out. You are not able to.
23 years.
23 years.
And so far, this.
So you are for the natural death.
No.
What do you want then?
Will not stand on the way. So far, the other will be.
This is unfair. See, somebody is. But 23 years you are not able to
decide whether it belongs to
pune post or
that reason. But it is.
Pune post also. You can't give him the pune post also.
Give pune post.
See that order, 2002 order.
3/4/2004, 24 also, this Hon'Ble Court directed to observe in any class 4 post also, but 3/4/2024.
This is atrocious. One pune cannot be appointed in compliance with the order of the tribunal.
And this rate,
they are taken out. This is in the year, my lord. 2018. 2018.
Imagine.
But order of the tribunal is 2002.
This is of 2002. 2 minutes.
Order was made in which case actually?
This is in OA.
OA number?
1700 of 2002.
17.
Hello? 1700
was filed in 2002.
OA was filed in 2002.
The contemplation was dropped on 2010.
2017.
15 years tribunal has taken to decide this matter. Brother, shall we direct which secretary? Which is the secretary of the department?
Let him come.
Let him come before the court. We will not agree with this. We will impose a 5 lakh rupees cost.
This is
2002 matter, 2017 tribunal decides. We are in 2025.
Not able to decide whether vacancy
is there or not is not being there. No?
And direction is given, at least appoint in class 4.
Class 4 also.
Don't do.
No, we'll direct the appearance of the.
May I take a last call, my lord? So far this, because they are taking steps, how can this person be appointed against the post of driver?
How many years are required for ascertaining?
Well,
even if ascertaining is same, the vehicle, when they reach the destination.
When, my lord, there was no such appointment after this, my lord, because they belongs to the.
No, we are not all that. Do you want to comply with the tribunal's order or not?
No, my lord, I have every respect and regards, my lord.
Respect
that should be.
We don't can respect and still you defy. We don't want respect. You want post.
My lord, so far the availability post is concerned because it is in process.
It is not available.
Post is not also.
For that, may I take a last call, my lord? For that purpose, can he be observed period of that post of non-availability of the driver? So far the person or other class 3.
Sweeper, some post.
On 7th also.
For that also vehicle necessary. This is too much. We will direct
it will be on Tuesday, my lord.
Call this matter on Tuesday. Hopefully for reporting compliance of the order in question. Non-compliance may result into some penal action of great consequence. Yes. But rest is small people. They will lose faith in the government and also in this court. Yes.
Item 30.
Item 30, my lord, allotted to my lorded senior Mr. G, my lord. He is suffering from fever, my lord.
G appears in this matter.
My lord. Lordship may kindly taken it to next week. He is suffering from fever, my lord.
Mr. G, the arguing government counsel is suffering from fever, is reported at the bar. First time. Call this matter week after next.
My lord.
Week after next.
Item 31.
May I please your lordship, here some defects are there. I will rectify it. Let it be taken up next week, my lord.
2018 matter.
Yes, my lord. Defect, my lord. What has happened, my lord, your lordship, on the other day, at the time of hearing, it was detected that annexure 20 and 21.
That amendment has been allowed.
Allowed.
But you have not submitted the consolidated.
I'll correct it and.
Counsel for the petitioner submit.
Next week.
We agree that within 1 week, the necessary steps.
Within 3 days, my lord. Within 3 days, I will do it.
1 week, we'll call it after. Week after next week.
Next week, my lord.
Counsel for the petition.
Consolidated petition copy to be submitted and with copy to us.
Already submitted. About the copy to us. Anybody would I know.
Next.
There have been adjourned. Item 34.
34.
I am for the petitioner in 34, your lordship. May we kindly be permitted to appear online, your lordship? Lordship, the issue in question is how the suspension period is to be decided when the government has not taken decision under FR 54B. There were several judgments on the issue, but the Honorable Tribunal has gone totally beyond, your lordship, the mandate of the law and has given an order.
Mandi, please hold on. He's saying something.
This was issued, though my record shows that counter affidavit was filed through online, but 4 hard copies are there and I verified no counter is there. I have sought a copy through online to my learned senior also. Let me file the hard copies of the counter affidavit. Matter may be taken up next week any day.
Next week.
Lordship, because I come from Delhi, can it be 9th of February? Because the other matter day before when I appeared, your lordship, I kept up 9th of February.
That's the my thing.
All this matter.
And if you can give a copy, the petitioner is in court, copy to the petitioner also the reply. It will be very easy.
Hard copy.
Highly obliged, your lordship.
The meanwhile, you are for respondent.
Mine, Union of India.
Lovely CGC.
Mine.
CGC appeal for Union government shall serve copy of the counter
affidavit
along with all the documents from the counsel appears for the petition. Yes.
Item 35.
Item 35,
Mr. Senior Counsel, Mr. Manoj Misra is appearing in this case, Your Lordship. Yesterday, my Lord.
What you want? Are you ready? Or you want?
I'm not ready, my Lord.
After 2 weeks, request of knowing.
I have objection because they have taken the interim order and I am unable to get my full pensionary benefits after
everything. I am filing this objection.
2 weeks it will come. I will not grant any. We will not grant time.
You also kindly indicate.
Fine. Yes.
Item 36.
But
36.
36 I have the respondent.
Lordship,
to my clients for instruction.
Oh, Lordship, kindly see last order, 7-8.
That is order.
7-8-25. 2 orders are there, my lord. 7-8-25 and.
So I have to send a last mail.
Time and again they're taking time. I am on the verge of retirement, 32 years service not regularized, my lord. Again, sanction post.
Yes.
Adjournment to seek
7-8-25 order, my lord.
relating to regularization of service.
Yes, my lord. That was the order. I have sent a mail to the head of his Delhi office. Again today I will send mail. You will also keep it to 10 days after.
They are not paying 7th pay, 6th, 5th pay, 6th pay. They are receiving because of pendency of the case. They are not paying.
We will give them 10 days.
My lord, as lords.
Finally. Call after 10 days. Finally.
My lord, I am appearing for OP number 1, my lord. Union of Ireland.
2 to 4 blood.
They release it.
Yes.
They release it 4th pay and 5th pay. 5th pay, 6th pay. 7th pay, they will not release it because of pending cases.
Next.
Item 37 has been adjourned. Item 38.
My pleasure, Lordship. It's a matter relating to revision of pension to the appellant hearing. My caption writ petition has been dismissed on a ground of misconception of factual.
You are referring?
For the state, but the accountant general was already issued. Patra is appearing. Sudhir Patra is appearing for the accountant general. He is the contesting.
You are for accountant general.
No, I am for the state.
State.
But the manager Sudhir Patra is appearing for the AG.
Contesting.
Who is the contesting party?
Contesting by the state government.
State government is the contesting party. AG is only accounts.
The pension has been held up in the accountant's website.
No.
I have utilized the counter filed by the Advocate General, wherein it has been said that I have retired from the post of MPSW, and multi-purpose health supervisor. The judgment under challenge passed by the Hon'Ble Single Bench. He has said that I have not retired from the post of multi-purpose health supervisor.
You retired from which post?
They said that I have retired from the post of sanitary inspector.
Not,
but the record available on the facts available on record that says, as well as the counter filed by AG, that I have retired from the post of multi-purpose health supervisor. That is the position to be adjudicated.
Where is that document?
Yes, sir. Yes. First, let me call for the attention of Lordship, page number 47.
Whether counsel for the AG is present here.
This is
Accountant general.
AG is not present. That's right.
Present.
Not present.
To keep you inform him.
I will inform him.
I will call this matter next week.
My lord.
Finally. Call this matter next week. It's the request of the DA.
Let it in the 11th.
11. 11th is which? 11th is which day?
On Wednesday.
Sunday.
No, 11th is Sunday.
It will be on, sorry.
Next. The request of.
Let him not 12.
It will come next.
12 of 13.
Item,
yes.
Item 39.
39 also allotted to my lord senior lords
G.
Mr. G.
Next week. Second note of the state council is the G. Solve this matter in weeks. Okay. Yes.
Item 40 has been added. Item 41.
May business. This case arises dismissal of my contempt petition by the Central Administrative Tribunal. I have approached this Hon'Ble Court. The case was allowed by the tribunal. It was not challenged. Direction was.
What was the direction?
Direction was for only, my lord, have a glance to the order. I have annexed the entire order also, the original order, annexure 4. My lord, only page 38. I shall read.
Service on opposite party number 3 to 6 complete.
I can't follow.
Service.
Service, I have to check.
All the notice was issued.
The notice issued, yes.
Service.
I have not checked.
Service is complete. There is a positive direction.
Yes, my lord. My lord.
So far as parties 3 to 6 are concerned, requisites for issuance of notice before 4. 3 to 6.
See, whether 3 to 6 are served. Not written. Not written.
Tracking
Or also not written.
There is a tracking report.
What is the tracking?
1, 2, 3, and 4.
Notice is served.
6 is not served.
1, 2,
3, 4.
1, 2, 3, 4.
I've seen
6 not served.
Not 6 it is.
These are the officers, my lord, in the contempt petition. They were the officers working at the relevant time. So I made them parties. This was the. Now probably they might have been transferred or something like that. I have no issue.
You have implemented, you have to serve them. What to do?
Because otherwise, my lord, my petition is not complete.
Huh?
My petition will not be complete because then their contempt petition, they were parties. I made them party here.
No, at least if you say that they are transferred elsewhere.
Yes, they are not. My instruction is unless.
Who should assert on that? What is the designation?
My lord, 1 is secretary, 5 is Mr. V. Srinivas, secretary in the Ministry of Personnel, Public Grievances and Pension, New Delhi. Another is 6 is Basudha Mishra, IS Secretary, EPSC, Gulpur House. EPSC was contesting there. Let me there. These are officers.
My lord, in this case, today I am appearing for the Union of India. Today I filed my proposal.
You are appealing for central government.
UPSC is reprinted. Notice how UP3 is the UPSC.
Generally, who appears for UPSC?
UPSC, there are penal counsel in the tribunal. My lord, Mr.
Here,
UPSC, the central government.
Separate panel.
I don't know.
Panel, okay.
Substitution General, my lord.
So, name, right up.
Therefore, CAD there's. They were the Central Administrative Tribunal. They were the council. I don't.
Here, who appears?
Here, my lord.
They have panel, na?
Here, I have no instructions.
Well, we will call this matter next week. In the meanwhile, you are certain.
I will settle it, my lord. Only thing I will say, my lord, this officer I made them parties. Officers, they are not appearing. That is why.
If you give up, no, they are not served at all.
No,
only 4 are served. 2 are 5, 6 not served.
That person, the officers, that person.
If you give up, we will take up this matter.
Yes, their office, my.
Because in contempt you had made them party.
Yes, personally. That is my difficulty. My lord was. That is the procedure, my lord, I have to follow.
Correct. That's true. This arises from the contempt order only.
Yes, contempt petition was dismissed. There was a positive order, tribunal said no.
Why tribunal says no?
What shall I say? That tribunal has said in the order, we are not satisfied. This is not a willful.
An order is amenable to
read. That judgment is there, my lord. In the
interpretation.
No.
Then it can say that.
The simple English sentence in the order. Promote him.
Was that all?
What is the logic behind saying that?
Why dismiss?
But they say, there is not willful or deliberate violation.
No.
That is the finding, my lord.
That is for the contempt for the purpose of enforcement.
Yes, that is my submission.
For compliance, they may not be willful. All these things will not happen.
They have said so and dismissed my case. That is why my lord have issued notice in this case. And only the maintainability was raised. Maintainability was raised at the initial point. I have given that judgment of the Supreme Court, which is maintainable under 226. That I have no. That is there. So my lord have accepted that.
I will take first steps. Something to be done. Answer to parties.
I have to. Yes, my lord. My lord, may take, my lord, to keep it to next week so that I can take instruction from my client whether these officer retirements are done.
OP numbers 1, 2, 3, 4 have been duly served. However, are not represented before this court.
No, my lord, today I am appearing.
You appear for 1.
1, 2, 3.
OP1 is represented by learned TDC. TDC, Sri so and so. First one.
I am for the 4, my lord.
2, 3, 4.
I am for the 4th.
2, 3. OP number 4 is represented by learned AS. Mr. Gray. First one. OP numbers 2 and 3 are 3 have chosen to be unrepresented despite service of notice. First one. Counsel for the petitioner submits that he would take steps in respect of OP, fresh steps in respect of OP numbers 5 and 6 by way of emergent notice.
The correct address, my lord, message so that it will help.
By providing correct address. Correct address. First one. For accomplishing the task, call this matter week after next.
My lord.
I am pardon.
Yes, what not really. With them.
Deflection. Well, I will pardon. Item number 38. Accountant general.
You appear for accountant general. But you are not there.
Just I'm coming from old building then.
All right. We have not shown any absence from 38. 38, we are calling this matter next week.
Ma'am.
Yes.
Item 42.
My appearance was not perfect, sir. My appearance was.
Yeah, next.
Item 42.
My lord, I am for the petition only. Posted for counter, my lord. Is that
I am appearing for the opposite partner 1, my lord. The Minister of Steel and Mines, my lord, I have not received the reply in this case. But, my lord, the opposite partner 2 and 3, those are, my lord, Steel Authority of India and Rourkela Steel Brand. They are the necessary parties to appear and to file counter because they are contested before the law trial.
You appear for them.
No. Lord, their notice had gone and they are not appearing.
Yes, if they do not appear, we can't wait for the counter.
And
we
also,
decide with the petition itself.
In my lord, I was not, Steel and Mines was not before the law tribunal. He has been incorporated here, and for that I sought for instruction from them.
What you want? You want time or you want to argue?
I want time.
You want time? You are for OP number?
1, madam.
Counsel for the OP number 1 seeks a short accommodation. First up, call after 2 weeks. In the meanwhile, counter may be filed if any, failing which, right to file 1 stands forfeited, and petition amendment may be taken with face value. Sorry.
Item 43 has been disposed of. Item 44.
Yeah.
Lord, in this petition, my lord, I have challenged the order, dismissal order of my application filed under section 14 of the SURFACE Act. By
enforcement of
for passing the order for the appointing any commissioner to take possession of the property. This application was rejected by the landlord magistrate on the plea that one of the borrower, being a corporate entity, is under CIRP, Corporate Insolvency Resolution Process, under the IBC, Insolvency Bankruptcy Code. Hence, the moratorium under section 14 of the IBC would be applicable to section 14 of the SURFACE. So it is rejected. That is the moot question. So here 2 legal issues arises.
There is 2017 Justice Nariman's judgment.
I have cited
judgment.
I have cited that. It is there in the first order also.
Bajaj Finance. 2022.
2017 Supreme Court was there, na?
My lord, it is 2023 once SEC 662. Sorry. I'm sorry. Your lordship is right. 2018-17 Supreme.
1817.
My lord. Lord, before we getting into this issue, the first issue arises.
These are come for admission today.
Notice was issued. My lord. The first issue is whether the magistrate is competent to adjudicate the legal issues between the parties, whether section 14 of the IBC will be applicable to 14 of SURFACE or not, it's a legal issue.
He cannot undertake.
He cannot adjudicate that.
Let us read section 4.
Operation of a moratorium on a particular proceeding, who will decide? The person who is dealing with the proceeding.
Not under SURFACE. Not under SURFACE.
Let us read that section 14, that moratorium section.
IBC.
Yes.
Subject to provisions of subsection 2 and 3, on the insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following, namely, the institution of suits or continuation of pending suits or proceeding against the corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or other authority. B. Transferring, encumbering, alienating, disposing of...
No, that is not necessary. The 2 itself covers. Once there is a moratorium, any authority who is holding, see the words,
for corporate debtor,
other proceeding.
For corporate debtor, only property is of the guarantor.
Only corporate debtor.
Only corporate.
So the property belongs to the guarantor. My issue is that property belongs to the guarantor. This judgment, the Honorable Supreme Court has clarified that if the property is the guarantor, the SURFACE can proceed.
The loanee suffers the proceeding.
The loanee, the main borrower, being a corporate entity, is suffering CIRP.
Guarantor is not entitled to protection.
Because they have further explained also, the Honorable Court, that is why the 95, 96 provisions are there for the personal guarantors.
Very clear.
Where are your friends?
What was issued, but there is a legal question. I am not asking anything on merits.
True.
The first question also, I would like to raise whether the magistrate is competent to adjudicate.
But that question will not arise because there is no moratorium against the opponents at all.
Beyond corporate debtor.
Beyond corporate debtors, no moratorium.
That's the law.
Your case is against the guarantor. He is not the corporate.
No, he is not.
That's what.
That is mentioned in the rejection, the order itself, that property belongs to a particular person who is a guarantor.
Who are your friends? Or your opponents? Friends or foes?
They did not appear since beginning. Not appearing.
From the beginning, they are not appearing.
Notice service is complete. Notice issued. Notice was sufficient, I think.
Item received.
Yes.
Routine stage. What is final?
Or Lordship can keep it a week after.
Let us see the service week first.
Service is completed.
Complete.
Yes.
What I received.
Short and white. Short. The second command. Petition calls in question the magistrate's order made under sections 14
of the SURFACE.
14, subsection what?
That is 14.1 of the SURFACE on the plea 14 of IBC.
14.1 of the SURFACE Act 2002, whereby the foreseen proceedings under section 14 have been negatived by the learned magistrate by the order dated
25.3.25, page 19 of my bill.
On the ground that some proceeding is pending against whom it is pending?
Corporate debtor.
Corporate debtor loan. That is the Despite service of notice, the OPs have chosen to remain absent. And that would not deter the court from adjudging the cause brought before it, in accordance with law, as rightly submitted by counsel appealing for the petitioner. First off, having heard the counsel for the petitioner and having perused the petition paper, we are inclined to grant indulgence in the matter, broadly agreeing with the submission of counsel for the petitioner that the magistrate would not have negatived the proceeding only on the ground that IBC proceedings are pending against the corporate debtor, in as much as the moratorium contemplated under section
14 of the
IBC does not extend to non-corporate entity. Wide apex court decision in State Bank of India versus P. Ramakrishnan, 2018, 17 SCC 394. First one. Next paragraph. The vehement submission of learned counsel for the petitioner as to the jurisdiction and competence of the magistrate to adjudge the question as to moratorium effect need not be gone into by us, in as much as the first question treated in the immediately preceding paragraph is answered in favor of the petitioner. First one. Next paragraph. In the above circumstances, this petition succeeds. Third grounds. The writ of certiorari issues quashing the impugn order and matter is remitted back to the jurisdictional magistrate for fresh consideration on merits within an outer limit of 6 weeks. That 60 days or how many days?
60 days is maximum, 30.
Unless you put the within a period of 60 days from the date of record from this day. Record from the date of receipt of the order. Record from the date of receipt of this order. First one. Magistrate to send copy of this order to the OPs by speed post immediately. First, no pause.
If they decide on merits, it comes, that would go against.
On merits, he should decide.
Not in merits. He cannot decide on merit. That is the Supreme Court.
No, that question will not arise
in accordance with law. The merits touches the adjudicatory power, my lord.
No, not like that, brother. It is merit does not mean whether one has borrowed or not. These things are not within the conspectus of his jurisdiction at all. 14 is has to give effect to the order.
It is basically not an adjudicative method.
He cannot adjudicate at all. We are in agreement with you.
No, that is the law. That yes, I agree. I bow down to your lordship. But
this goes up in accordance with the law.
This goes up in accordance with the law.
Merits, delete that. So he may mistake that and start growing in. On merits to be
Lord, I have repeatedly opposite party 1 million.
You for 1 million. Next.
Item 45 has been disposed of. Item 46.
My lord, in this case, Union of India is the petitioners in 3 cases challenging the administrative CAT order and the last order of this Hon'Ble Court, my lord, on 31/10/2025.
Yeah.
It is clearly stated in that the prayer person is quoted that it is therefore prayed that this Hon'Ble Court may be graciously pleased to admit the application and this. The impugned order dated 4/4/2020 passed in OA number 3 issued by the learned Central Administrative.
What is that? Notice is issued.
Yes, my lord. Notice is issued. And on second para, it is clearly that Mr. Sopna, my learned senior, learned counsel has already entered appearance. No, my lord, the court has decided to adjudicate the matter finally at the stage of admission, my lord. My lord, today matter is listed, and I have got some decision as well as the Learned Cat Calcutta order, which I have to prepare. So next week on 15th matter may be listed.
This issue has already been settled by the Honorable Appeals Court. I have given that note also, and still, my lord, we are the retired persons.
First of all, the writ petition arising out of a proceeding under this CAT proceeding and all. No counter, no regency.
Nothing.
Over there, the pleading we will decide.
No, I am not. Has already been, because the court has, since the court has specifically stated that it at administration it will be filed finally, I collect some documents which I am not ready. So next week on 15th.
You have said in one sentence, I need time. We have happily granted to you. How much time you are taking for wasting? Yes. Next at the request of learned counsel for the petitioner, he made long submission unwarrantedly. Yes.
Item 47.
On 15th, next week.
For my your lords. Your lords, kindly fix a date, my lord. Only that much.
Which year matter it is?
Lord?
2025 matter?
Yes, my lord, 25 matter. And
2 weeks, some date may begin 2 weeks.
Very low.
21, 22.
On 19th.
Yeah, 19. Call on 19. You yes, have said I only need time.
No, my lord, my only.
All right.
Because my learned senior pursuing the contempt petition there, therefore here is admitting to half the matter and con. Therefore, I am saying time.
So you will not stop arguing even when grant relief which you want. You wanted time, we have given. Still you want to argue, go on arguing. Yes.
Item 47.
Maybe possible. My lordship, the paper book which we have received is not legible. So in pen drive it may be.
Take it in pen drive and no order is required for that. So now the position of here, what is the paper is pen drive also being there. Order for classified document. You can take it. But the petitioner applicant submits that the hard copy of the evidence and trial court record available with him is not legible. So therefore, he needs a soft copy of his orders. He may obtain soft copies from the registry in these matters.
Yeah. Item 48.
Hearing matter.
Nobody.
Item 49.
Needs all the matters are hearing with us. We go to the
It's the Jeritanal appeal.
what is there?
Item 50.
Put the matter next.
Why? Your amicus curiae are supposed to be ready?
No, my lord. Amicus curiae not jail final.
Or jail, okay, it's all right, but you should be ready. Accused has trusted you to argue the matter. Not request. 2 weeks, not next week. Next week, lot of
One pass over.
no.
Item 6.
Of next.
Item 6.
You are appealing? 6?
No, you are not. That is a private.
State is not a party.
The private.
None appears for a 2 weeks.